It's a criminal appeal. More than 1 year, the appellant is in jail. So we have filed IA for bail. It may kindly be listed on 5A.
Criminal appeal senior court is there. Same roster is taken up by another court.
POXO matter, man.
No.
POXO is there, so special act in this court, as I have seen the cause.
Special act only for bails.
No, criminal appeal with bail.
Give me the roster some. There is a senior court taking up same roster.
POXO is written in this code. I have checked that seen. That's why my lord I mentioned.
Only special,
Special.
only in bail matters. Otherwise, all other criminality appeals, two benches are taking up. You have to mention before the senior court. That is the rule.
Hey, please, Your Lordship. Lordship, I'd like to mention a bail application for withdrawal, Lordship, on Monday.
Okay.
I'm praying for that one bail application, Your Lordship fixed it today, my lord. He's in jail, my lord, but that not been listed, my lord. So, my lord, the last item, my lord, because he's in jail, my lord. Fixed today, my lord.
No, if it is bail, he has to be in jail. So that need not to be told.
I fixed it today, my lord, but somehow left out, my lord, in the list.
There is a judicial order.
Yes, my lord, I have take, my lord. Today fixed.
Okay.
Wait, please, Your Lordship. I beg to mention item number 36. Matter may be taken up at 2 PM, Lordship. On the last dated, Your Lordship, I was waiting and case diary also received, but not reached. So kindly
Today it will reach.
at 2 PM.
No, no. See, we'll take it up. We'll take it up serially. When the matter is called, you wait for your turn. We'll take it up seriously.
Kindly pass over this matter for that way. And I have taken the consent from the
On request of learned counsel for the petitioner, Ms. A. Mehdi, let this matter be passed over for the day. Yes.
Before Lordship, I said before Lordship, and for anticipatory bail, it may be taken, my lord, unlisted matter at 2 PM, because, my lord, in this case, the petitioner is, there is a case against the petitioner and who is undergoing operation for his diabetes 430 mg at Guwahati, my lord, and blood leaking from his left hand middle portion. For this reason,
When have you filed?
my lord, yesterday.
Okay. Okay.
Thank you, Lordship. Lordship, I am making a prayer for adjournment, Lordship, of item number 53 was listed yesterday also. And the special request of the learned public prosecutor was listed today. Lordship, I am led by Mr. B.K. Mohadan, and he is indisposed, Lordship, he is in hospital. So I have taken consent from the public prosecutor also.
We'll not extend the interim bail. We'll allow your prayer. But without any extension for interim bail.
In that case, he will be in trouble.
No,
Otherwise,
we,
Lordship,
because you are on interim.
Yes, Lordship.
Remaining on interim, you cannot extend when the prosecution is opposing your bail.
Only 2 days, Lordship.
We will extend it without any utterance regarding extension. Heard. Mr. Item number?
53, Lord. Maybe taken up on Tuesday.
Tuesday,
Lordship,
ma'am.
No, we are allowing.
I have taken the consent from my friend also, Lordship. There is no objection from his
You are
side.
consenting.
Consenting Lordship because of the medical ground.
Medical-
We also have
Yes,
an
sir.
emergency. Lordship.
Item number 50.
3, Lordship.
Heard Mr. R. Sharma, learned counsel for the petitioner, who prays for an adjournment on the ground that the counsel, Mr. B.K. Mahajan, who would be appearing on behalf of the petitioner, is indisposed. Considering the ground mentioned by the petitioner, learned additional public prosecutor does not raises any objection, hence the prayer is allowed. The other cases are fixed when?
40.
Okay, on Tuesday. Let this matter be listed on Tuesday, 5th of August.
Much.
Interim shall continue, interim order shall continue.
Let it be on fourth itself.
No, let it be on 5th. Ground.
Much.
Wait, please, your lordship. I beg to mention item number 22, lordship. Kindly matter may be adjourned for the day, lordship. My senior has some difficulties, medical lordship checkup for.
Heard Miss J. Ghosh, learned counsel for the petitioner who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. The prayer is allowed. Case diary is there. Learned additional public prosecutor also prays for some more time for producing the case diary. The prayer is allowed. Let this case be listed on 21/8. The interim order shall continue till next day.
Okay, lordship.
Lordship, back to mention item number 13, Lordship. So in this matter, Lordship, we have an information that Shashit has already been filed.
Rashid, late.
Lordship, this is CM vigilance. CM vigilance.
So you are withdrawing.
No, Lordship, just the confirmation, we don't have the confirmation.
Then you have to wait till the matter is called.
Item number 1.
None has appeared for the petitioner on call. It appears that on last two occasions also, nobody appeared when the matter was called. This bail application is therefore dismissed for non-prosecution.
Item 2.
It's a charge sheeted matter, LCR may be called.
Heard Mr. N.J. Dutta, learned counsel for the petitioner. Also heard Mr. K.K. Miss
NCB.
M. Deka, learned counsel for the NCB. Let the scanned copy of the trial court records along with the scanned copy of the connected case diary be called for the from the trial court. Let this matter be listed on 26th of August.
I'm okay.
Okay. Wait,
Yes,
this is for surveillance application, lordship. Petitioner behind the bar. Since 20.
microphone check the desk.
Lordship, petitioner is behind the bar since 27 2025. And the acquisition at page 11, Lordship. Page 11 is that. May I read, Lordship?
27?
27.
27, Lordship. 27.
Why
Page 11
why
is-
the prayer was rejected by the trial court?
Lordship, in fact,
You have not moved. Then we'll call for the case then. Heard Miss T. Som, learned counsel for the petitioner. Also heard Mr. D.P. Goswami, learned additional public prosecutor. Call for the case then.
if for a very short date, Lordship, if the perusal of the affair would justify that.
No, you,
a short date, but it's No, it is from cyber. Guwahati, Ulubari. This is from Ulubari only.
14.
Next week, Lordship.
14. It may not be part.
8 or 9, Lordship, 8 or 9. 9? 8 or 9, Lordship.
12th. Yeah, 12th, Karibu. 12th.
I think 4.
Also give it an NDPS matter, Lordship. Charges has already been filed.
Heard Miss J. Singh for learned counsel for the petitioner. Also heard Miss M. Deka, learned counsel for NCB. Learned counsel for DRI. Let the scanned copy of the trial court records along with this. What is the ground?
Prolonged incarceration. Lordship.
The scanned copy of the trial court record be called for from the trial. List this matter. 27-8.
Item 5.
Please, your Lordship, the matter may be passed over for time being.
What is the matter?
POXO 6 is there, Lordship.
We are issuing notice.
State case.
What is your name?
K. Das.
Heard Ms. K. Das, learned counsel for the petitioner. Also heard Mr. D.P. Goswami, learned additional public prosecutor. Call for the scanned copy of the trial court records and issue notice to the respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice upon respondent number 2 within 3 days from the date of this order, returnable on 27-8.
Item 6.
May it please your lordship. My lord, I am Shivam Sharma from Lucknow. I may be permitted to conduct this case through video conferencing with your lordship's kind permission, my lord.
Yes.
My lord, the applicant before your lordship seeks bail in NDPS case wherein a truck of carrying bottles of Escos in commercial quantity was arrested. My lord, the case is squarely covered by your lordship's order in a similar matter almost granted last month that a
Is
person
it
who
a
has
charge
spent.
sheeted case? Is
My
it a
lord.
charge sheeted case?
Yes, lord. My lord.
What is your ground?
My lord, he has spent almost 4 years in jail. There is no earning member in the family. He has a child of 7 years, only a wife. And besides, my lord, the arrest memo and notice which are on page 10, the grounds of arrest were not mentioned to him. So on these 2 grounds alone, he may, if I may invite your lordship's attention to page 10, my lord,
4
which is the
years.
arrest. May I read for your lordship's convenience, my lord?
Is there anything else apart from the arrest memo? Ms.
My lord,
Deka,
first, as I
where
humbly submitted that in the memorandum of arrest on page 10, and that is the notice on page 11, the grounds of arrest are not mentioned. Lordship has found them, my lord?
there may be other documents in the charge sheet,
My lord,
in the
this
case
is
diary.
there is a mandatory requirement, and there's a judgment of order of your lordship also, if I may invite, that long period of incarceration, even in cases of commercial quantity in NDPS, would entitle the person to bail. If your lordship's pleasure might be to have page 35, my lord, I have appended an order of your lordship in almost similar circumstances.
Not in this case.
My lord, NDPS matter of commercial quantity. Not in this case number, but NDPS matter of commercial quantity where
No, what
quantity
is
of
the status of the trial?
my lord, only 3 witnesses have been examined, 3 more to go. There is 1 independent witness who is still to be examined. And I have spent 4 years in jail now, my lord. Almost 4, 1 month less.
We'll call for a status report from. How much is the contraband?
My lord, there is a truck load of this bottle, my lord, a few cartons. I'll just indicate the exact quantity, my lord. It's a commercial quantity.
3,102 bottles of S-cup cough syrup, lordship.
Could your lordship be persuaded for a moment to have page 35, my lord? I'm sorry, page 30, para 35. This is an order of your lordship.
Page?
Page 30, my lord. I'm only reading the relevant, inviting your lordship's kind attention to the relevant paragraph.
No, we will call for a status report from the trial court as to stage, what is the status of trial?
My lord, with all humility and respect, could I say that applicant undisputedly has spent 4 years in jail? And in the case on which I'm trying to persuade your lordship, my lord, he had spent 3 years and 3 months. So on this score alone, if your lordship may be persuaded to enlarge me, with nobody to take care of his family, my lord, only a child of 7 and his wife.
There may be call for
Yes.
lordship, if necessary lordship.
Could your lordship may till
Why
then
it is necessary? Yes, sir.
I'm in your lordship's hands, my lord. Could I humbly persuade your lordship to consider his pitiable condition, my lord?
No, suppose the delay is because of you. Unless we peruse the records,
My
how,
lord.
how can we find out what is the
with-
reason for
my lord,
delay?
Could
That
with great respect,
may-
my lord, with all the respect that I can command, can I say that even if assuming for a minute that there was some fault on my part, there is nothing to prevent the state from proceeding with the trial of 4 years. And he's
No.
languishing in jail, my lord. He could not have put any obstacle in the course of the trial. my
No,
lord. Somebody,
merely because if there is long incarceration and if it is not because of your fault, then you may get benefit. But
My lord.
if there is fault on your part, the court may take other view also. And
I
that has to be verified.
bow
Therefore, we
down
are
to your,
calling-
my lord. I
What-
bow
what
down
is
to
your
that
name?
observation.
What
I'm
is your
Shivam
name?
Sharma. I'm
Heard
Shivam
Mr.
Sharma from Lucknow.
Heard Mr. S. Sharma, learned counsel for the petitioner appearing through video conferencing. Also heard Ms. M. Deka, learned counsel for NCB. This application for bail under section 483 of BNSS has been filed by the petitioner Amrendra Kumar Singh, who is seeking bail on the ground of long incarceration. Stop. Let the scan copy of the trial court records be called for from the trial court. Put let the date due shorter. Let this case be listed on 26th of August.
I'm deeply obliged. Could I make a prayer, my lord?
Yes.
Would your lordship be kind enough to say, my lord, high up on board so it may be taken up? I'm not aware of the procedure of your lordship's high court. If that liberty may be granted.
What is the prayer?
Could it be high up on board, my lord, just after fresh, so that it may be taken up?
No. You don't know where, at what serial it will be listed in the cause list. Otherwise, it may be otherwise listed in the top. You have to wait for the cause list of that day.
Obliged, my lord. I'm deeply obliged for the patient indulgence, my lord.
Item
Hello.
7.
Wait, please, your lordship. My lord, sir, diary will be required, my lord. NDPS case.
Heard Mr. N.J. Dr. Learned counsel for the petitioner. Also heard Mr. D.P. Goswami, Learned additional public prosecutor. Call for the case diary. List this matter,
Samoguri,
18th of August.
18th of August.
I am obliged.
Item 8.
My lord, in this case, my lord, earlier I approved, my lord. Lordship, can you peruse the order dated 21, page 21, 25, my lord. Then he approached the law court, my lord, again. And law court, session court rejected the bail, my lord. And the accused is arrested on, he was arrested on 21/2/2025. 4 months has gone. And
Trial
page-
is going on.
Trial is-
Why it was rejected?
Lordship, can you peruse the rejected order and accept file?
Page number?
Page 24, Lordship, it appears that today is the session.
Charges have been framed, Lord.
Frame, my lord, charges has been framed.
And next day 24/7 for
Next date
evidence.
is 24/7/2025.
Already saw the frame, that's it, that's why it is rejected.
He is more than 4 months, my lord, in jail now. So the custody is not necessary. No? Okay.
What is your ground? Let the victim be examined. Charges has,
Already
is-
framed.
let the, this is a rape case, at least victim has to be examined. We are disposing it off with a direction that after examination of victim, you may move the trial court. Heard Ms. K. Devi, learned counsel for the petitioner. Also heard Mr. D.P. Goswami, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner Abu Hussein, who has been detained behind the bars since 21/2/2025 in connection with
Agomani, please.
what is the sessions case number?
14825.
1482025.
In connection with sessions case number 148/2/2025 pending in the Court of Learned Sessions Judge Dhubri. Learned counsel for the petitioner has submitted that the petitioner has been languishing behind the bars since 21/2/2025 and charge sheet has already been laid and charges are framed. And she further submits that the petitioner is ready to face trial. And unless he is released on bail, he may not be in a position to defend his case properly. On the other hand, learned additional public prosecutor has opposed the grant of bail at this stage and has submitted that this case involves the offense of rape and no witness has yet been examined till date. He submits that at least material witnesses should be examined before the prayer for bail of the petitioner is considered. I have considered the submissions made by learned counsel for both sides and have gone through the record of the case. It appears that it appears from record that in the trial of the sessions case number 148/2025, charges have been framed under section 394(2)/64(2) within bracket small f within bracket small k of BNS. And the victim has not yet been examined. And on that ground, it also on that ground only, the trial court had rejected the bail of the petitioner on 10/7/2025. This court does not find any error in the order of rejection of the trial court. Considering the nature of offense involved in this case, and as well as the fact that victim and the informant are not yet examined, this bail application is dismissed at this stage with an observation that the petitioner may approach the trial court and may file a regular bail application before the said court after examination of the victim girl, after examination of the victim as well as the informant as prosecution witnesses by the trial court. Go before the trial court.
Item 9.
After some time, maybe give it to them.
No, after victim is examined, you can move before the trial.
Highly obliged.
Item number,
May I please your lordship?
yes.
Lordship, it is a regular bail application number 2455/2025. Lordship, FIR has been filed in respect of Gorsuk PS case number 194/2025. On received information, one vehicle bearing registration number AS 15AC 5591 carrying urea fertilizer of 80 bags and 35 bags of salt. Lordship, we were arrested on 27/06/2025 and in judicial custody from 32 days and 3 days police custody, Lordship, total 35 days. Lordship, we want to mention that the bags containing urea and salts not illegal as mentioned in the FIR. It has
Why your prayer was rejected by the,
Lordship, we
And-
unable to produce the tax invoice at that time, Lordship. That's why session court rejected our bill.
Yes, 26 and
Lordship, I want to submit one more document in this regard. Lordship, we were innocent and only the driver and handyman and only performing our duties towards our owner,
which
Mr. Kadam.
police station?
Gorsuk.
We are fixing a short date, calling for
Case
case
diary.
diary. Let the case diary come, we'll examine. Heard, Mr. What is the name?
It's Patar.
R. Pator, learned counsel for the petitioner.
Lordship, kindly fix a short date.
Yes, also heard Mr. D.P. Goswami, learned additional public prosecutor. Perusal of the case diary would be necessary for consideration of the instant bail application, hence call for the same. Short. 12th of August.
Obliged.
Maybe. But if I is fees method 10 method. But only 1.58 kg cook meat my lot suspected to be fees method. Take over from my vessel.
Who are you?
But I am the owner.
When you were arrested?
My lot, I am arrested my lot on
170.
Yes, Mr. Goswami.
Yes, that's already similar order I have in it.
Heard, Mr. What is your name?
Yes.
Heard Mr. A. Hussain, learned counsel for the petitioner. Also heard Mr. D.P. Goswami, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Rakib Ahmed, who has been detained behind the bars since last 1/7/2025 within bracket for last 30 days in connection with North Lakhimpur PS case number 226/2025 under section 61 within bracket 2 within bracket small a /298/299/196(2) of BNS read with section 13 within bracket 1 of Assam Cattle Preservation Act 2021. The gist of accusation in this case is that
Actually, my lord, I was arrested on my lord 17 my lord, but have been forwarded on 27 my lord.
on 1/7/2025, one Utpal Bora, SI of police had lodged an FIR before the officer in charge of North Lakhimpur Police Station, inter alia, alleging that on receipt of an information through reliable sources that one hotel, namely Khelmati Mughlai Garden Hotel, situated at Khelmati, is selling beef in contravention of the provisions of Assam Cattle Preservation Act. A search team was constituted and the said hotel was searched. During search operation, 1.58 kgs of suspected cooked beef meat was recovered therefrom. Learned counsel for the petitioner submits that petitioner is the owner of the said hotel and he is ready to cooperate in the investigation. Stop. On the other hand, learned additional public prosecutor has prayed for calling of the case diary. Stop. I have considered the submissions made by learned counsel for both sides. It appears that the petitioner has been detained behind the bars for last 30 days and only 1.5 kg of cooked beef meat has been seized in this case. Considering that the suspected beef meat has already been seized and the petitioner has been detained behind the bars for last 30 days, this court is of considered opinion that his further custodial interrogation may not be necessary for fair completion of the trial, for fair completion of the investigation of the aforesaid case. Stop. Considering the above mentioned, in view of above, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the learned Chief Judicial Magistrate. Lakhimpur, not Lakhimpur. This bail application is accordingly disposed of.
Obligation.
Immediately. Okay, this is a commercial quantity, NDPS, is under investigation stage, and I am behind the bar since 4/2/25. Okay. Yes, Lordship, only my submission is this short date may be fixed because I have visits that grounds of arrest has not been communicated, not been issued and not been communicated to me in my
When?
understandable language.
When can you?
Lordship, it will be because I am languishing more than 6 months, Lordship. Certainly.
How much is the contraband?
8 kg.
8 kg of?
And also one pistol.
8 kg of?
Yeah, per tablet. Mathematics.
As
Also one
per
pistol
convenience of
found in his
Lordship.
possession.
Heard Mr. D. Ullah, learned counsel for the petitioner. Also heard Mr. What is your name?
D. Bora.
D. Bora, learned senior standing counsel, DRI. And let the case diary be called for. When suggested date?
Your Lordship, after August 18th, Your Lordship, 19th or
On
20th.
19th.
19 I'll be August
Okay, 20. Let this case be listed on 20 August.
Highly obliged.
May it please your lordship.
Yes.
Lordship, the accused person was arrested on 6/6/2025, and this is the second bail petition. Your lordship.
6.
6/2025. And sections are, your lordship, 16 clause 2, which is the 2 years of imprisonment, and 318 clause 4, 7 years of imprisonment, and 363 clause 3, forgery, 7 years of imprisonment, and 340 clause 2, fraudulent and dishonestly used forged documents of electronics records. This is the 2 years of imprisonment.
Where is your earlier rejection order?
Page number 20, Annexure 5.
What is the ground for second bail application?
Chief ground is here, lordship, where the bail was rejected on the last date, BA number 2121/25, our co-accused, namely Zakaria Ahmed. The accused person has pleaded the guilty that he has collected the money from the public, your lordship, and submitted those money to the petitioner, to this petitioner. But we did not receive any, my petitioner did not receive any money from the Zakaria, your lordship. There have no any evidence should be collected by the CIDPS, your lordship, only on the confessional statement. Co-accused statements are not acceptable. It is not a part of the evidence according to the Kutupan Singh judgment, your lordship. And your lordship, on the last dated where the order was rejected, here mentioned that DA number 2121.
We'll call for the case diary again.
60 days is festival. Only 4 days is left, your lordship.
So wait for 4 days, you will know.
Length of detention, your lordship, kindly, and the petitioner has a minor child also. I have annexed in this petition, your lordship. Kindly go to page number 19 of the annexer 4.
Early orders of case diary
Lordship,
produced in
on
supplement
annexer
of
4. This is the only the confessional statement, your lordship. I have arrested. No any evidence would be collected by the CIDPS, your lordship. On the last order of also, your lordship, when the rejected on the BA number 2121/25,
Right.
Zakaria Ahmed directly said that we have.
Will you
taken
be
the
able
money
to
and
produce the case diary on 5th? 5th, you will be able. Heard Mr. Miss Amy Learned Counsel for the petitioner. Also heard Mr. KK. Also heard Mr. DP Goswami, Learned Additional Public Prosecutor. This is for the second time the petitioner is approaching this court seeking bail in this case. His earlier bail application was rejected on 24/7/2025 after perusal of the case diary. Hence, let the case diary be called for. Release this matter on 5th of August.
Item 48 from supplementary.
Make the roll of, madam. It's a regular bail application, madam. Arrest in custody since 27/25. Here possibly, my lord, day before yesterday, possibly diary was there, and lordship was pleased to grant made the interim bail absolute of a co-accused person, my lord. So diary may be there any day, my lord, if possible in the next week, Monday or Tuesday, if possible.
When is the case?
Other case or disposed of by your lordship, my lord. Earlier, there was an interim order that was made absolute possibly, my lord. So, here,
What is the case?
case my clash in a, my lord, that coke factory, my lord, between two groups of laborers, my lord, and unfortunately, one laborer died, my lord.
No, but the bail was granted to the,
Different. I'm not on that. What I meant is that my diary may be there. That's why if possible, a short.
diary is there.
Any day, Monday or Tuesday or Wednesday.
Okay, if diaries, if they can produce the case diary.
Yes, sir.
Heard Mr. A. Chaudhary, Learned Counsel for the petitioner. Also heard Mr. DP Goswami, Learned Additional Public Prosecutor. Learned Counsel for the petitioner has submitted that a bail co-accused, some of the co-accused were granted anticipatory bail by this court, and therefore there is a possibility of the case diary available in the court or in the office of the additional public prosecutor. On the other hand, learned additional public prosecutor submits that he requires to verify this. However, if same is available, he will be in a position to produce the same. Produce it before the court on 5th of August, list accordingly.
Much obliged.
Item 49.
Well, it's a application of 483 of the BNSS, my lord. Yeah, my lord. But here the accused person before lordship, he is in custody from 6/7, my lord. That is around, my lord, 26 days in custody, 25 days in custody, my lord. And here, my lord, two offense has been attributed, my lord, have been attributed. One is bailable, my lord, that is section 7 of the Essential Commodities Act, my lord. And my lord, regarding, my lord, 305E, my lord, possibly that won't be affected because there is no allegation that these are stolen property of, my lord, it has been stolen from some, there's no FIR.
Why your prayer was rejected?
Well, I preferred an application, my lord, there are 2-3 dates were given by the learned court, my lord. So we withdrew it and we approached this honorable. court.
We will call for the case.
Here, my lord, we have the CD of another case in 38. I can tell you.
Case there is available.
Available in 38 number.
We will take it up along with 30.
But. One ago. Okay.
Please, your lordship. Okay, in this matter, lordship, FIR has been filed by the vigilance, same vigilance. In sections 120B, 13A, 113A, 13(2).
Who is representing? Who is the counsel?
So in this matter, lordship, matter may be passed over for a delay.
Okay. Cause list should have shown special PP instead of PP. You inform who is Mr. Kotoki? You inform the special PP. We'll take it up after some time.
I am sorry, my lord, I waiting. It's back, my lord. My lord, in this case, my lord, it is under section 482 of the PNS of my lord. The lordship will get the FIR at page 13. In this case, my lord, I am not a prime accused or my lord, I am a name accused. The accused is my lord, one my lord, Chittaranjan Dev, my lord. In where it is stated in page number 14, lordship will get. The information received from a reliable sources reveals that Dr. Chittaranjan Dev, senior professor of the director of the IQSC, Dean of the School of Science, Department of the Botany, Nagaland University, Limani, is indulging in the various corrupt and the illegal practices. It is alleged that with the predetermined intention to cause wrongful loss to Nagaland University and the corresponding personal pecuniary gain to him in the matter of the favorable award of supply order of the scientific equipment, consumable, etc. He is allowing favor of the different bidders companies against the obtaining undue advantage of bribes. Source further reveals that the various occasions Dr. Chittaranjan Dev demanded undue advantage bribes from the Ravindra Kumar Jain of Jaladhar and Company, Jorhat, Assam, against the supply order of ₹5 lakhs, which was already been delivered by Sri Ravindra Kumar Jain to the university.
Who are you?
Well, I am Ravindra Kumar Jain, my lord. Well, the fact is, my lord, that so far even I have been dealing with the link up with the Jaladhar. I am not the proprietor of the Jaladhar. Jaladhar is a proprietor, is a Kamal Jain, my lord. I have relevant document, I have annex of 5. And the my lord, so far the bribe, my lord, is concerned that I am delivering. It is totally based on some, my lord, without any basis and without any concrete proof, my lord. It is an allegation. So this so far the accused is concerned, my lord, they have created a search operation in the vehicle wherever he was coming from, my lord, Gangtok on the way to Jorhat from the airport. And accordingly, the search operation also conducted in my office. And they have seized one mobile phone as well as one, my lord, tax invoice receipt containing 3 pages. So in that aspect, my lord, I have been directed to, if it is required, I will go to the this CBI office to give my deposition and other things. But I will cooperate everything.
No, you received some notice.
I have not, because search has been, my lord, conducted. I have annexed, my lord, the document. This is annexed to at page 16. Whereby my search operation has been conducted in my office and 2 articles have been seized, my lord. I have type copy also given, the certified copy also.
No.
Please, your lordship. In this case, he is the supplier in the department. And moreover, in the page number, may I please your lordship, I will bring your kind attention in paragraph number 7.
Page number?
Page number 7, paragraph number 7. Admittedly, his father is the proprietor. It is given in page number 6, Bimal Kumar Jain, father of the petitioner.
So his father is the proprietor and both of them are doing the business, supply work. They used to supply the material, scientific equipment and some consumable goods. And in paragraph number 7, it is admittedly, here it is given, they have paid rupees 66,000 to the account of the wife of the accused person, as the property is registered in her for taking the said rented premises from the period 1/2/2024 to 31/3/2024. It is required to be noted 66,000 they have given for a month. And same has been reflected in the ledger of the Jaladhar company for the year 2024-25. And because of the said tenant landlord relation, the petitioner has built a close relationship with the accused Chittaranjan Dev. He is the officer. He has been, he was there working in the capacity of scientist or some officer. And they are in the close relation. It is an admitted fact. And he has paid an amount of rupees
No,
66,000.
that is for the rent only.
That is,
too matter.
they have taken the plea that has been given as a rent, but they are in the close relation with the officer and he is the supplier. He is the supplier. This is the way they develop the relation, get the favor.
No, what is the accusation against him? That he paid bribe?
Yes, so it is there. If I am going by the
FIR1.
FIR. FIR is at
Page
page
14.
number. Sir, we need some time to give an appropriate reply and we'll bring also the CD. Page 28, I am coming to the page 28 here also. Page 28.
Do we require his custodial interrogation? You have to
His
verify.
cooperation is required the moment they are protected, they never cooperate.
I'll always.
If they
cooperate.
don't cooperate, we'll reject the bail.
Yes, my lord.
Or you need to verify from the diary whether custodial interrogation is.
Some time to.
How much time?
At least 2 weeks required. Objection is required to be filed and we'll bring the CD. Or at least minimum 10 days, because after preparing the objection, it has to be proved by the higher authority. So it requires some time. But his name is
they
not
will
there in FIR, he did not have to afraid of. Let him cooperate.
If I am not afraid, then why will they are insisting
Definitely,
on that,
that
they
is,
don't know.
that is the part of investigation to maintain the law and order. One has to go for investigation, see the conspiracy larger, there may be some larger conspiracy.
There is no.
That
proof,
is the
my lord.
part of the maintaining the law and order. Investigation, calling anyone for the purpose of investigation or searching any premises doesn't mean that he is accused or may not be accused.
Then
He should cooperate.
Then they should have known any objection or in giving any.
No,
interpretation,
that,
my lord.
that,
The same thing is happening.
outright I cannot give no.
So every submission is like that. my
At
lord.
least you can wait for 10 days. We are ready to give the reply and
Heard Mr.
CD will be bring.
P. Mahanta, learned counsel for the petitioner. Also heard Miss
Certain call details are also there.
Miss M. Kumari, learned standing counsel CBI. This application under say. How much bribe is taken?
As
What
per
is
the
the
allegation,
accusation?
my lord, they said that 2 lakhs, my lord, I have paid. My lord, nothing has been paid.
2 lakhs is. And another 15,000.
And that too, my lord, kindly see, my lord, the allegation that on that.
Let you produce the case diary within short date.
Then by 8, 9, 10 or like that, August.
Let her produce by 8. We'll consider your prayer on perusal of the case. Heard Mr. P. Mahanta, learned counsel for the
My
petitioner.
lord, one thing, my lord. My lord, as per their allegation, my lord, they kindly turn to page, my lord, this 15. 15. This is a little trouble to lordship. My lord, the first paragraph, my lord, sources further disclose that the Chittaranjan Dev will be visiting Jorhat on 12/7 and it is apprehended that he is likely to meet Sri Ravindra Kumar Jain for obtaining undue advantage of bribe of rupees 2 lakhs, my lord. As per their affair, it is not happened till now.
But he has been arrested.
I was not arrested, my lord.
He has been arrested.
I was
That
not
is why
arrested.
they-
When Chittaranjan was arrested,
He was also not arrested, my lord. Chittaranjan also not arrested.
That I will
Only
have
charge
to
operation
see.
was conducted. Well, this is my affidavit I have given. They said that probably they will come to collect the rupees, but that was not happened till today.
This
Your
is
own
an
FIR is
FIR
contradictory.
only after the registration of the FIR proceeding starts. So I need to have some respect.
This is why, my lord, I am so.
Apart from the press report, I have gone through the news, that is why that may not be authentic.
Also, Ms. M. Kumari, London Standing Council, CBI. This application under section 482 of BNSS has been filed by the petitioner, namely Ravindra Kumar Jain, who is apprehending his arrest in connection with CBI, ACB. FIR number RC 0172025 A0006 0007 dated 12/7/2025 under section 7 of the Prevention of Corruption Act 1988. When can you produce case diary? Shortest.
8.
We will peruse the case diary. 7, section 7 of the PC Act. Stop. The case was later on registered as RC7 within bracket A/2025. Considering the nature of accusation made in the FIR against the present petitioner, perusal of the case diary would be necessary. Hence, call for the case diary. Let this case be listed on 8th of August.
8 of August, when Marty given, huh? But that can be even on 6th of August.
Well, it would be
So it is a
very
too long-
shorted
too
because
late.
tomorrow
Today
is
is the
Saturday. and
First one,
Sunday.
my lord.
We have to take the approval from the competent
Let
authority.
it be on 8th. 2
Well,
days will make
fine.
only.
Acha.
First,
May please. So this is pre-arrest bail application lordship, and this case lordship has it already been late
Cash sheet laid.
lordship, and the shown absconder lordship charge sheet will find page number 19 lordship, translated copy. But here, as per the charge sheet lordship, but I have gone through the entire charge sheet, but there is nothing attempted by the police to arrest the accused person in any point of time since the FIR is lost. And even then the charge sheet is totally silent and never visited the house of the accused person, either not serve any notice under section 41A to the petitioner lordship. So my lord, here in this case, lordship, in the meantime, lordship, the trial court lordship issue NBW against the petitioner. Now my little prayer lordship, they are ready to appear to the court below lordship and face the trial lordship. Here in this case, lordship, the total 8 numbers of accused lordship, 13 numbers of
No,
accused.
why you did not appear when you received summons?
So lordship, NBW is issued lordship.
NBW has been issued after your failure on appearance.
The section is lordship session tribal, there is the problem lordship. One of my little prayer lordship, and since the case is registered in the year of 2019 and charge sheet is submitted in the year of 2021, and they are the local person lordship and permanent resident. Police never visited their house lordship and even never take any point of time to attempt the arrest the accused person lordship. And they are the permanent resident lordship. One of my little prayer, they will be faced the trial lordship. Otherwise, that is the Game and Betting Act is their lordship. Some dispute is arised between the police.
140, yes, Mr. Goswami. 143 is also there.
yes, sir. Entire investigation, he was not cooperating with the
But
investigation.
the
And
marketplace lordship,
lordship.
some dispute is arised.
charge sheet already submitted, so he is a lordship.
Another aspect lordship may mercy lordship and para number 7 lordship in my petition. And recently lordship there
All the petitioners have been shown as absconder.
8.
All 8 petitioners
No,
there.
I arrested in the spot lordship. And they are playing game and betting lordship in a marketplace lordship, weekly market. And some
5 petitioners are,
arrest, 5 accused were arrested, and now lordship, the petitioner 1 to 8 lordship, all they are absconder lordship.
and they were arrested.
No, lordship, absconder. Arrested another 5% lordship, total 13 numbers of accused.
Where is the FIR?
Fire is page number lordship. 13 lordship and operating person lordship. 13 lordship. May I read the original one lordship and it is visible and page number 18. Permit lordship. Game and Betting Act was there lordship and some
Charge sheet has been laid under what provision?
section which lordship you can kindly come to page number lordship. 23 lordship, last part of the charge sheet lordship. Page number 23. During the I forgot lordship.
Yes.
During the course of investigation, witnesses are examined. After examining the witnesses, but the case is established under section 143, 353, 338, 333 of IPC. After completion of the investigation, lordship and the summons lordship. This section is attributed against the accused person. Lordship, another aspect, lordship, and now they are the very odd condition, lordship, and the recently lordship one eviction is.
Why 143 was included?
There are lots of people in marketplace, lordship. Numbers of people.
143 of IPC.
Lordship. Punishment, whoever member of the unlawful assembly shall be
So
punished
what is the maximum punishment?
6 months, lordship.
Maximum punishment for the offenses.
7 years, and which may extend to 10 years, that is 333, lordship.
Then why are you, then you appear before the trial court,
So, calculate this one.
trial court will consider your bail.
333 is the session tribal, lordship.
What is the punishment?
7 years, which may extend to 10 years, lordship.
Still trial court can grant you bail. No.
Lordship. Otherwise, all the petitioner now they are in homeless condition, lordship. Recently
No.
eviction, lordship.
You appear before the court which issued,
NBW is there,
when is the date?
tomorrow, lordship.
Appear tomorrow. And pray for bail.
NBW is there, lordship.
We'll
Okay, Lord.
stay the NBW till tomorrow. Heard. Mr. F. Hawk, learned counsel for the petitioner. Oh.
Later, lordship, some. we will not reject one of us.
No, where is the apprehension? F. Hawk, learned counsel for the petitioner. Also Mr. D.P. Goswami, done an additional public prosecutor. This application under section 482 of BNSS 23 has been filed by the petitioners. Have you received summons? Still you have not appeared.
Later, lordship, they are evicted recently, lordship, they are in homeless condition, lordship. Kindly may consider, lordship. And that is why I am very clearly mentioning in my petition, para number 7, lordship.
No, that is a different fact.
Yeah, lordship, there is the Game Betting Act was there. lordship.
This application under section 482 of BNSS has been filed by the petitioners, namely 1, 2, 3, 4, 5, 6, 7, and 8, who are apprehending their arrest in connection with PRC case number 954 slash 2021 under section 143 slash 353 slash 338 slash 333 slash 307. 307 is all.
Charge sheet, no, 307 is not there. In charge sheet.
307 not active. Nature
Charge sheet, lordship,
of the
143.
Indian Penal Code. Read with section 13 slash 14 of the Assam Games and Betting Act. Learned counsel for the petitioners has submitted that the trial court has issued non-bailable warrant of arrest against the above named petitioners, and the next date of appearance is fixed before the trial court tomorrow. He further submits that why you could not appear when the summons were issued to you? Have you made any statement?
Lordship, yes, I have received the summons, but I could not appear, Lordship.
What is the reason for which you could not appear? You may make submission. I have not heard anything. You have to.
But Lordship, actually, and as per the one petitioner, Lordship, and they could not arrange the bailor, Lordship. And that is why, Lordship, and that because all they are the same relatives.
Learned
That
counsel
basically
for the
unable to
petitioner has submitted that though the petitioners have received summons, however, as they could not arrange the bailer, they defaulted in appearing before the trial court, and now non-bailable warrant of arrest have been issued against them, and therefore they are apprehending their arrest. Stop. On the other hand, learned additional public prosecutor submits that the petitioner may approach before the trial court and may pray for bail before the said court. Stop. I have considered the submissions made by learned counsel for both sides. It appears that the petitioners have defaulted in appearing before the trial court in spite of receiving summons from the said court, though they have stated reason for the same before this court. They could have appeared before the trial court also and mention the reasons for the default before the said court. Stop. It appears that the maximum punishment for the offenses involved in this case is not more than 7 years. Therefore, the court which issued the non-bailable warrant of arrest against the petitioner is competent enough to consider and to grant bail to the petitioners if it thinks fit to do so. As the PRC case number
954,
95
954, 2020.
954/2021 is listed before the Court of Learned Additional Chief Judicial Magistrate, Walpara. Tomorrow, this bail application is disposed of with a direction to the petitioners to appear before the said court, and after their appearance, they may pray for to appear before the said court on the fixed date. Stop. After their appearance, they may file a regular application for bail before the said court, if so advised. So to facilitate the appearance of the petitioners before the Court of Learned Additional Chief Judicial Magistrate, Gwalpara, on the date fixed, that is tomorrow, 2nd of August 2025, the operation of non-bailable warrant of arrest issued against them by the trial court shall remain suspended till tomorrow. This bail application is accordingly disposed.
Order is sent tomorrow, it will.
No, we'll upload it. Vishek, isko aaj hi upload. We'll upload it tomorrow, today itself.
Sorry, Lordship, one thing, Lordship, and 333, and punishment imprisonment for 10 years and fine cognizable, non-bailable, triable by court of session, and non-compatible. That is why, Lordship, and the court below may not be, Lordship.
एक line डाल दो. Though the offense under section 333 of the Indian Penal Code is liable exclusively by court of session. However, as the maximum punishment
Yes.
provided for the said offense is only 10 years, the Court of Learned Additional Chief Judicial Magistrate Gwalpara is competent to consider and to grant bail for the grant bail to the petitioners, even for the said offense, if it finds fit to do so under the facts and circumstances of the case.
Rakesh Pal case, Lordship, up to 7 years. But it is, which may be extended 10 years.
Appear tomorrow and convince the trial.
Obliged.
Negligible Lordship. Okay, I could not contact the chief counsel.
পিছত মাতিব যেতিয়া both side আহিল. No, you want to take adjournment on request of learned counsel for the petitioner. Let this case be listed on Monday, on Tuesday, 5th of August.
CM business নামটো show কৰিব লাগিব তেতিয়াহে আহিব গম পাব
Let the cause list reflect the name of Special Public Prosecutor, CM Vigilance, as counsel for the respondent in this case henceforth.
16.
Should kindly come to page 9. 9 is the FIR Lordship. And this FIR was lost on 13/6/2024 by the police Lordship. May I read Lordship this FIR?
Yes.
With due respect and humble submission, it is to inform you that on so and so at so and so, I along with the staff so and so, performing night patrolling duty at Sokurmara area. We observed the below noted and other cattle smugglers were making conspiracy and pre-planned manner coming towards Indo-Bangladesh border to smuggle cattle from India side to Bangladesh side over the border fence. I along with the staff challenged the smuggler to stop, but the smuggler did not pay any heed. And
What is your name?
My lord, my name is Lordship Tahir Islam. That is your Lordship will find at page 11, serial number 7, in the name of column of the accused. My lord, in fact,
We'll call for the case study.
what happened, Lordship, in that I am not the smuggler, I am the villager, Lordship. On that particular day, Lordship, while the police confronted with the smuggler, Lordship, some altercation took place and thereafter they started firing. Subsequently, Lordship, some village people, Lordship, they came forward and some verbal altercation, Lordship, has taken place with the villagers. And on that particular day, Lordship, my grandmother expired, Lordship. I was so much busy with my parents, Lordship, on the death of my grandmother. And according to, I was not aware that my name has been included in the FIR. This FIR, after 1 year, the police Lordship is trying to, Lordship, the police officer, IO of the case, Lordship changed. And he is trying to, Lordship, arrest the petitioner. Then I came to know that my name has been included in the FIR, Lordship. I was not, no way, Lordship, involved. I was not there in that. I only the villager of that particular village. If your Lordship grants some protection, Lordship, I will appear and cooperate with them. That is my
become Lordship, allegations are serious, Lordship. Should he become Lordship?
Let the case study come.
some protection, Lordship. I will appear and my statement, Lordship, I will
maybe recorded lordship. I
No,
was not absolutely lordship on that particular, on that incident.
heard Mr. M. Khan, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Considering the nature of accusation leveled against the petitioner in the FIR, perusal of the case diary would be necessary for consideration of the instant anticipatory bail application. Hence call for the same. When? 18.
Lordship is not.
No,
Granting.
no, considering the,
Okay. Short it may be the lordship. Can you do 14 lordship?
okay, 14.
Oblige.
Item 17.
Nepal is lordship. But in the year 2019, members, CBI received some information from reliable source against 6 employees of RF Railway. Against Miller, there is an allegation, Miller, they have in the name of advertisement of in various newspaper, Miller, they have caused huge loss, which is more than 100 crores, Miller, to RPF Railway, Miller. Now, Miller, the main accused has already been granted anticipatory bail, Miller. And I am the proprietor of one of the newspaper, Miller. I'm 79 years old and I'm ready to cooperate.
You are the proprietor of?
Aquam Daily newspaper.
What is the accusation?
Your Lordship,
Why you are apprehending your arrest?
Your Lordship, kindly see Annexure 3, page 23. A notice was issued to me, Miller, under section 91 CRPC.
91.
Yes, Miller.
You produce the document which is, where is the apprehension? There is no apprehension.
Miller, the thing is that
91 does not
Does not.
raises an apprehension.
I have already submitted to whatever I have through my legal counsel, Miller. This is the second notice they have served.
No, you have been asked only to produce document.
Yes, Miller.
When is the date?
It is already 17/6/2025. Miller.
You have defaulted in,
Yes, Miller.
yes.
May I please, your lordship? This
You
is a
take
ma-
instruction whether is,
I will get the instruction, but I just would like to apprise you some instance. This is a matter of 2014 to 18. And probably the charge sheet has already filed. Of course, I have no knowledge with regard to the filing of charge sheet, but the matter is of 14 to 2018 pertaining to the NF Railway. This notice is issued on 28/4/2025 under section 91. Under section 91, it speaks about the production of the document. Now it is BNSS
Where is-
179.
where is the notice page?
Page 23.
Page 22 and 23, they are supposed to produce the document. Why they have come for this, such a old case, this is of 18,
There is no apprehension.
and that too,
Why are you apprehending?
I'm apprehending because, my lord, I have already sent my statement through my legal counsel, my lord.
so the legal.
Again, the second show cause notice has been issued.
Not show cause notice.
Sorry, my lord, again, the notice has been
A
issued.
notice
show
for
cause
production of
notice.
document only.
Those documents is not available with me.
You inform the CBI that
I've already informed me.
It's
I will
a
state
mere
it in my.
abuse of the process of law. In section 91, they
Against
wanted
my-
to, because he is dealing with the newspaper. His newspaper is known as some named as newspaper. It's a local newspaper.
Yeah.
Mm.
Yeah.
Local
no, he may
newspaper.
be apprehending because he has defaulted.
Newspaper named as the Aquam Daily. So all the advertisement of the NF Railway for the purpose of calling tender or invitation of expression of interest, it is going through their notice. Definitely at the time of this trial or any inquiry, they may inquire into the matter or they may ask for the production of the document. This is a scam of 100 crore only with respect to the advertisement in the newspaper. And the matter is relate sometime 2014 to 2018. Probably trial is going on. Some document is required. He is supposed to produce the document. It may be needed in the trial court.
So for my
So
information.
there is a such for
Oh, sir, madam,
91.
charge sheet has not submitted in this case, and the main accused is already granted 3 years.
Oh, that is of 18, 19.
Yeah, 19.
That is of 19
You,
again.
can you take instructions? And whether we'll take it up shortly.
That may kindly be fixed on 8 itself.
Okay, 8, let her take instructions.
Yep.
Heard Mr. I. Rafiq, learned counsel for the petitioner. Also heard Miss M. Kumari, learned standing counsel CBI. This application, you have stated wrong section. This application under section 482 of BNSS has been filed by the petitioner who is apprehending his arrest in connection with CBI ACB case number RC 01720198 0006 under section 120B/409/420/468/471 of Indian Penal Code, read with section 13 within bracket 2/13 within bracket 1 within bracket C within bracket D of Prevention of Corruption Act. The petitioner, learned counsel for the petitioner has submitted that the petitioner has received a notice under section 91 of the Code of Criminal Procedure, 1973 on 28/4/2025 for production of certain documents before the investigating officer of the case. However, as the documents were not available with him, he defaulted in appearing, and therefore he is apprehending that he may be arrested in connection with the aforesaid case. On the other hand, learned standing counsel CBI submits that mere receipt of a notice under section 91 of the CRPC does not give any reason for apprehension of getting arrested. She submits that this notice is only for production of document which the petitioner should have complied with, and even if documents are not available with him, he could have informed the investigating officer about the same. However, same does not give any apprehension of arrest. After considering the submissions made by learned counsel for both sides, learned standing counsel CBI is requested to take instructions from the investigating officer and let this court know as to whether arrest of the petitioner is required, whether custodial interrogation of the petitioner.
91 application.
No, you
It is
take
not
oral.
mandatory. It
We
is
are not
mandatory.
calling for the case, Harry. But whether it is required or not, you can.
Right. Say even because if there is any larger conspiracy which will be revealed subsequently.
No, you
as of now,
take oral instructions. And
60. Had it been under section 160.
of that I know. What is it?
I will take the instruction.
You take oral instructions, and if he answers in affirmative, we may call for the case diary. If he answers in negative, then this application is not maintainable. We'll reflect your submission.
If required, we'll file some written objection also, or some written submission if required against this application. But I don't think anything is,
Because you don't know now.
I don't.
Of the petitioner would be necessary in this case. Let this case be listed on 8th of August.
Right.
Wait one and see.
May I please hear me? This is the third application, Lordship.
Third,
Third application, Lordship.
what happened to first two?
First, your Lordship, the order is at page 61, Lordship. The first application was rejected because Lordship, it was observed that there was incriminating materials against the accused persons, and the involvement amount was much more. That is rupees 3,25,000, 3,25,29,657.
What is your name?
My name is your Lordship, two petitioners,
Siraj.
Kulen Burman and Lordship Jumi Burman. Lordship. In this case, there are
Where is the rejection order?
page 61, the first rejection order, Lordship. On page 66 is the second rejection order.
What is the ground?
Lordship,
New ground.
new ground is in this case, Lordship. Kindly peruse page 54, annexure 5, Lordship.
Page 50.
54, Lordship. Annexure 5. The relevant, it is at page 58, Lordship. Kindly peruse page 58, paragraph number 16. This bail application was filed by, this was the second bail application, was filed by one Mr. Kiran Das, who was the then branch manager of the State Bank. And the prosecution considered him to be the kingpin of this case, Lordship. Kindly come to the paragraph number 16, Lordship, page 58. On perusal of the records available before the court, including the case diary, BIO case number 6 of 24, it appears that the earlier anticipatory bail application of the petitioner was rejected on 6/1/25, almost 4 months ago. It appears on perusal of the rejection order that though incriminating materials were found against the present petitioner in the case diary, however, the main reason for rejecting the prayer of anticipatory bail was involvement of huge amount of money, that is 3,25,29,650. However, considering the submission made by the learned senior counsel of the petitioner as well as documents produced before this court, that is article of charges issued to the petitioner, this is important, Lordship, issued to the petitioner in connection with the disciplinary proceedings initiated against him with regard to the same allegations by the bank authority, it appears that accusation against him is regarding misappropriation of amount of rupees 25 lakhs, which is much lesser than the earlier projected amount of rupees 3,25,29,657. In this case, Lordship, the then branch manager was supplied with articles of charges, and there was revelation of amount of rupees 25 lakhs. The much lesser amount, Lordship, the informant has lost FIR, Lordship. And the FIR itself reveals that there was the suppression of the amount of rupees 25 lakhs because they have lost the FIR in respect of amount of rupees 3,25,29,657. So this is basically my new ground in this case.
So how it helps you?
Because there is in Your Honor, kindly peruse the FIR, Lordship, page 22. And relevant is at page 26, Lordship. There is a revelation of amount of rupees 25 lakhs. And they have lost an FIR of rupees. There was unlawful transaction of rupees 3,25,29,000. So there is itself a suppression of the fact that there was unauthorized unlawful transaction of rupees 25 lakhs. It is suppressed in the FIR.
No, it is not suppressed.
And another, Lordship, aspect of this matter, that though the FIR was lost on 10/9/2024, Lordship, and registered on 17/9/24, Lordship, till date, both the petitioners are not been arrested, Lordship.
That cannot be a ground.
Though my name is in the FIR lordship, there is a reasonable apprehension lordship. No, I am just pressing the assertion lordship, but there was in revelation of lesser amount in the context of the
Lesser
articles
amount,
of charges.
but incriminating materials against you remains same. How you will overcome that?
Though there is, your lordship, the revelation of lesser amount, this is in itself a new ground in this case, lordship. Because there is no mention of this rupees 25 lakhs in the FIR. And this, your lordship, and another aspect of this matter, lordship, this whole case is based on documentary evidence, lordship. All the documents have been collected, lordship. I have also praised this down also in this application, lordship. So my custodial
Yes.
detention may not be required, lordship.
My
And-
humble submission, lordship, no new ground, lordship, all this has been made before, and regarding, lordship, the amount that is been stated in the FIR, lordship, that is not a ground, lordship.
No, my query is in view of the grant of bail to Kiran Das. Who is Kiran Das?
He was the then branch manager, lordship, and the accountant of this case was also granted bail, lordship, Hiraj Burman. Page 50, the annexer 4, lordship.
You were the driver of some
I am
branch
driver of Kiran Das, lordship, during the tour, lordship.
in view
And
of,
and the second petitioner is my wife, lordship.
and your wife's account was used.
Used, lordship, as a conduit, lordship. The alleged by the
You find out or we call for the case
yes,
study.
case that
Is there any
will
call for lordship?
Heard Mr. N. Datta,
PK Basu.
P.K. Basu, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Perusal of the case diary would be necessary for consideration of the instant anticipatory bail application. Hence call for the same. When 18/17.
May it please your lordship. Lordship, this is an anticipatory bail. We have two petitioners before your lordship. In this case, lordship, these two petitioner lordship receive a notice under 35(3) lordship. On the first day, they have appeared lordship, and their statement was recorded lordship. On the day lordship, their mobile phone was seized by the CID lordship. Now, next date is fixed on 7th, 8th of this month lordship. So their apprehension is that lordship, since their mobile is lordship seized on the next day, they might have arrested lordship. That is the apprehension lordship. Because
What is the basis of that appeal?
yeah, that is lordship allegation they reflect in the page 16 lordship. This is a long FIR lordship. What happened lordship? Some school has been listed lordship, 6 school has been listed lordship in the inquiry report lordship. There lordship, some minority student lordship applied for, doing some applied for national scholarship portal lordship for minority student lordship. And some school have 1 or 2 student from minority community lordship. There's nodal officer was appointed lordship. When the inquiry was made lordship, the headmaster was asked lordship, then it is come out that lordship, those nodal officers are not actually lordship employed by the lordship, appointed by the school authorities lordship. In this way, lordship use money of scholarship.
When is the next date?
Next date is 7/8 lordship. Notice lordship will find on page. This two petitioner is the father and son lordship. Page 37 lordship. It's a notice for the petitioner number 2 and page 35 is the notice for the petitioner number 1 lordship.
When have you appeared earlier?
Earlier appeared lordship on 10/7 lordship. And the mobile seized lordship will find on page 39 and 40 lordship. Otherwise, lordship, it's an absolutely lordship based on a documented evidence lordship. This petitioner number 1 has a lordship at the computer center for uploading that lordship document in connection with this lordship scholarship lordship. Since OTP has come to his mobile lordship, that's why he was in the
suspicion, lordship, in the suspect list, lordship. That I have stated in my petition, lordship.
Yes, Mr. Goswami.
Page, para 5, lordship, page 6, lordship. Because mobile has seized, that's why the only apprehension.
Oh,
lordship.
why apprehension mobile?
Because that lordship, they may, lordship, what may come out from that mobile, we don't know, lordship, because.
You know what is there in your mobile.
That I stated, lordship. OTP is, I have a petition number 1 has a lordship, DTP center lordship is uploading that lordship document, lordship. So school authority send OTP to this because through his lordship, OTP lordship, this all some documents are uploaded, lordship. Now his mobile has been seized, lordship, and his father has been shown as a nodal in one school, lordship.
Heard Mr. B. Chaudhary, learned counsel for the petitioner. Also heard Mr. D.P. Goswami, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioners, namely Saiful Hussain and Sanwar Hussain, who are apprehending their arrest in connection with CIDPS case number 1/2025 under section 120B/420/468/471 of Indian Penal Code, read with section 66D of the Information Technology Act. The gist of accusation in this case is that on 4/1/2025, one Nirmal Biswas had lodged an FIR before the officer in charge of CID police station, Ulubari, inter alia, alleging that a complaint was received from the Secretary, Ministry of Minority Affairs, Government of India, wherein it was revealed that some fake beneficiaries and non-operation school institutes are there taking advantage asking for fake scholarships applications which have submitted fake scholarships application under scholarship schemes of Ministry of Minority Affairs. Learned counsel for the petitioners have submitted that both the petitioners had received notice under section 35(3) from the investigating officer, and accordingly on 10th of July they have appeared before the investigating officer. However, their mobile phone were seized. He submits that the petitioner are again called to appear before the investigating officer on 7th of August. And therefore, and as their mobile phones have been seized, they are now apprehending that as bailable offenses are non-bailable offenses are involved in this case, they may be arrested. The learned counsel for petitioner submits that the petitioners are ready to cooperate in the investigation. On the other hand, learned additional public prosecutor submits that there is no apprehension of petitioners getting arrested as they have complied with the earlier notification. Earlier notice under section 35(3) of BNS. He submits that if the petitioner complies with the present notice and appear before the investigating officer on 7/8, there may not be any apprehension of their getting arrested. So I have considered the submissions made by the council for both sides. This court is of considered opinion that considering the accusation made in the FIR, perusal of the case diary would be necessary. Hence, call for the case diary. Fixing 21(8) for the case diary. In the meanwhile, both petitioners are directed to appear before the investigating officer on 7th of August 2025 in pursuant to the notice received by them under section 35(3) of BNSS. Stop. If they do so, comma, in the event of their arrest in connection with the aforesaid case, they may be allowed to go on interim bail of rupees 30,000 each, with one surety of like amount, subject to the satisfaction of the arresting authority, with following conditions, number 1 and number 2. List accordingly.
Highly obliged. Obliged.
May I please your lordship? 482 application, my lord. Offense under section 299, 196 subsection 2, read with section 13(1) of the Assam Cattle Preservation Act. Lordship will find the FIR at page 11. Allegation is that lordship, one police team has raided the shop, that is the hotel. In fact, it is a hotel, my lord, under the name and style of Bismillah. Page 11, lordship will find it.
Yes.
And recovered around total 44 kg of meat suspected to be of the beef. The fact of the case is that, my lord, this hotel, that is Bismillah, the petitioner is the owner of that particular hotel, but same is managed and run by his staff, lord. And on that particular day, while he was at home, he was informed by his staff that police party has raided his hotel and subsequently seized the meat from the hotel premises. So I am ready to cooperate with the investigation, my lord. I am the permanent resident of Sangsari. I am ready to appear before the IO lords. I may kindly be protected, lords. Custodial interrogation may not be necessary, my lord.
Yes.
Only thing is, the owner of the hotel, he well aware of the fact that he is from where he the beef is collected.
Admittedly, I am the owner of the hotel, my lord. I am not concealing that fact, my lord. But only thing is that the hotel is being run by my staff, and on that particular day, I was not present in the hotel.
At least let us peruse one case diary in such case. Heard.
P. Das, lord.
Mr. P. Das, learned counsel for the petitioner. Also heard Mr. D.P. Goswami, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner Aznur Ali, who is apprehending his arrest in connection with Sangsari PS case number 136/2022 under section 299/196 within bracket 2 of BNS 2023, read with section 13 within bracket 1 of Assam Cattle Preservation Act 2021. The gist of accusation in this case is that on 1/7/2025, one Bharat Dole, SI of police had lodged an FIR before the officer in charge of Sangsari police station, inter alia, alleging that on receipt of an information through reliable sources regarding illegal slaughter of cattle and illegal sale of beef meat in contravention of the provisions of Assam Cattle Preservation Act 2021, a search team was made and a search was conducted in the, what is the name of the shop?
The shop name is Bismillah,
In the,
Hotel Bismillah. In fact, though it has been mentioned as a shop, but it is a hotel, Hotel Bismillah.
in the shop of the, what is your name? Aznur,
Aznur Ali.
shop of the petitioner Aznur Ali. During search operation, 44 kgs of suspected beef meat was recovered therefrom. Stop. Learned counsel for the petitioner has submitted that the petitioner is the owner of the said shop from where the suspected beef was recovered. The name of this shop is Hotel Bismillah. He further submits that the said hotel is managed and run by his employees, and he is unaware about day-to-day affairs of the said hotel. He further submits that he is ready to cooperate in the investigation. Stop. On the other hand, learned additional public prosecutor prays for calling of the case diary. Let the case diary be called for. Let this case be listed on 22nd of August. Stop. In the meanwhile, considering the submissions made by learned counsel for the petitioner, as discussed in the foregoing paragraphs, the above-named petitioner is directed to appear before the investigating officer of Sangsari PS case number 136/2025 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with aforesaid case, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority. List accordingly.
Obliged, Lord.
Yeah, my lord, in this case, here is no FIR.
There is no FIR.
Right.
Why are you apprehending?
Because, my lord, in fact, my lord, the petitioner was called on by the All-Women Police Station on last 26/7/2020.
Petitioner was?
Called on by the policeman.
How you are cordoned?
By, my lord, our telephone, my lord. I have annexed the number. and the-
Petitioner was called.
Yes, my lord.
Okay.
If he was called, my lord. If your lordship is pleased to peruse the annexure 5-year, 4-year lordship, that is the call details. By this is the number 06026900591. This is the official number of the All-Women Police Station, my lord, Panbajar. On the ground that, my lord, my wife lodged a complaint theory against me, and therefore my interrogation was necessary. But on that particular day, my lord, I could not appear because of my medical ground, because on the 1st of June, my lord, I met with an accident. And moreover, my lord, I got some back pain, therefore I could not travel because the petitioner is a branch manager, my lord, at SBI at Dhubdara, my lord. And it would be risky for him to travel to the police station at Guwahati. Therefore, he sent his mother, my lord. But the OC, my lord, the All-Women Police Station, he did not share anything with the mother of the petitioner, and also used some, my lord, they also expressed some aggression.
But
against
you
the
could have applied for certified copy of the petition. FIR.
Because to our information, my lord, there is no case registered till date. Only the
Then let us find out
take inspection of
We'll call for a report.
Milord, till then, because I'm a branch manager at SBI, Milord. And that, Milord, prior to that, Milord, the entire, Milord, the dispute arose on account of a legal notice sent by my wife. That your lordship will find at annexure 2, page number, Milord, that is at page number 18. Because her allegation in the legal notice is that, Milord, since 20th of June 2025, I'm not cooperating with her. I'm avoiding her, Milord. But in fact, I met with an accident that was
No.
informed to her, but she did not went to see me. Milord.
What is the FIR? You
Milord.
know about the contents of the FIR.
Contents is that, Milord, the allegation of dowry and then mental and physical torture.
Where is the FIR?
No, that is the version of the police. When my mother went to the police station, that was informed,
That was informed.
Milord. Because the pursuant to the legal notice, Milord, I also placed my reply.
What is the name of your wife?
Wife is Sagarika Das. Sagarika Das. She has sent a legal notice. Your lordship will find it page number 18.
Yes.
They brought some allegation. So I am a branch.
Whether any cases they have lodged.
No, if police is not informing about the,
My lord. And I am a branch manager, my lord, then I cannot absent my duty, my lord. It would jeopardize my service, my lord. So till then, my
how,
lord,
how copy of FIR is,
not furnished.
If FIR is registered, then from the CGM court.
you can find out you can take the certified copy.
Yes, my lord, they are not furnishing, my lord, until and unless the FIR is registered, my lord. The party is not entitled to obtain the copy, my lord. Even I have applied.
So
for the
it
copy.
has not been registered.
So till that, my lord, because that I am not furnished with any copy. And I also inquired in the, my lord, PI code of the concerned CGM, my lord. But that no report has been forwarded to the PI code also, my
Okay. Heard,
lord. Yeah,
Mr. A. Ali, learned counsel for the petitioner.
my lord, in fact, subject to your approval, my lord. This because my mother was informed that they will register the case and forward it to the North Guwahati police station because my wife resides within the territorial jurisdiction of that police station, my lord. So therefore, this case pertains to the OC, my lord, whether that case has been registered or not, or any fresh complaint has been filed or not. So this direction would go to the my lord, OC North Guwahati police station. And for the all women police station, my lord, I have filed this separate petition. That is a next item. I have come with 2 separate petitions.
Okay. Heard, Mr. A. Ali, learned counsel for the petitioner. Also heard Mr. D.P. Goswami, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner,
There are 2 petitioners. The
by
mother,
the petitioners, namely Debashish Haloy and Srimati Joba Haloy, who are apprehending arrest in connection with an FIR which they suspect that it has been lodged by the wife of the petitioner number 1, namely Sagarika
Das.
Das in All Women Police Station, Panbajar, and same has been forwarded to the North Guwahati Police Station for registration. However, the petitioner is unaware about the registration of any such FIR in the North Guwahati as of now. So, in view of the submissions made by learned counsel for the petitioner, let a report be called for from the officer in charge of North Guwahati Police Station as to whether any FIR lodged by Ms. Sagarika Das has been registered against the petitioners Debashish Haloy and Joba Haloy in the said police station. The said report shall be furnished to this court through the office of the public prosecutor on the next date fixed. Let this case be listed on 12/8. You find out
Lordship. But till then I may be protected.
In this
Because-
case, there is no protection is required.
Because my lord, I have to attend my office, my lord.
But in this case, there is no phone call. It is from the women police station in the next case
My
only.
lord.
In
my-
next case, we'll
my-
give some protection, not in North Guwahati before. Let the report come, then we will find out.
Yes, this is his connection with me, lord.
Heard Miss
Yeah, Ali.
Heard Mr. A. Ali, learned counsel for the petitioner. Also heard Mr. D.P. Goswami, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioners, namely Devashish Haloi and Joba Haloi, who are apprehending their arrest in connection with an FIR which might have lodged before the officer in charge of all women police station, Kamrup Metro, by the wife of the petitioner number one, namely Srimati
Sagarika Das.
Sagarika Das. Stop. Learned counsel for the petitioner has submitted that the petitioner has received a phone call from all women police station to appear before the police station in connection with a written complaint filed by the wife of the petitioner number one. Stop. He, however, submits that when the mother of the petitioner number one, that is petitioner number two, Joba Haloi, went to the police station, all women police station, and inquired about the said FIR, the police declined to furnish any information regarding registration of the case and insisted the appearance of the present petitioner number one before the said police station. The petitioner, learned counsel for the petitioner submits that the petitioner is apprehending arrest. And on the other hand, learned additional public prosecutor submits that since no information regarding registration of an FIR has been mentioned by the petitioner in his application, a report may be called for from the officer in charge of all women police station. Stop. Let a report be called for from the officer in charge of all women police station as to whether any FIR lodged by Miss
Sagarika Das.
Sagarika Das against the petitioners Debashish Haloi and Jaba Haloi has been registered in the said police station, has been filed in the said police station. If so, the details thereof should be sent to this court before the next date fixed. Let this case be listed on 12th August 2025. Stop. In the meanwhile, if the petitioners are arrested in connection with any FIR lodged by Sagarika Haloi, Sagarika Das in the said police station on alleging therein that she has been subjected to physical and mental torture and demand of dowry by the present petitioners, the above named petitioners shall be granted interim bail of rupees 30,000 each with one surety of like amount subject to the satisfaction of the arresting authority. List accordingly on 12th of August.
I'm obliged. May I please, your lordship?
Yes.
May I please your lordship? This is a case under section 96 of BNS, that is procreation of the minor lordship, and 64 of BNS corresponding to 76 lordship. So lordship, FIR will be find lordship page number 10 lordship. So in this case, what happened lordship, allegation is that her minor daughter has been taken away by the accused person and thereafter committed rape and
Where is the affair?
FIR, your lordship will find cancelled copy lordship, page 10 lordship. And lordship, vernacular personal lordship, page 15 lordship. It will be very convenient than vernacular personal lordship. May I read it, lordship permit me?
Yes.
Yes. এজাহাৰকাৰী নিবেদন এই যে এজাহাৰকাৰীৰ কন্যা বাৰ্বী চাহিনী বয়স 14 বছৰ বয়স লুথুৰাম হাইস্কুলৰ অষ্টম শ্ৰেণীৰ অধ্যয়নৰত ছাত্ৰী হয় পদকীয়া এজাহাৰকাৰী ঘৰৰ ওচৰৰ প্ৰতিবেশী যুৱক এজাহাৰকাৰী কন্যা যোৱা long time is behind the bar lordship and we have filed the
No,
bail
whether
application.
charges have been framed.
Charges framed, one witnesses has been already, victim has been examined lordship,
Victim has been examined.
examined lordship.
What she has stated.
Yes, lordship. This lordship, in the deposition lordship.
You have annexed that.
Yes, lordship.
At which page?
Page number lordship. It is starts from lordship. Page number 36 lordship. Got it, lordship.
What is the submission?
My submission is that she has, during the cross examination, she had stated that while I reached the place of her sister, her elder sister, and thereafter their mothers has reached there and took away. During the yes, lordship, I will. The kitchen was attached on the taken rice and so while we are having the rice, Rupa Sahani's husband called my parent and informed them that I was in their home. During that time, I was asked to sit in the kitchen. Before dawn, my family members reached the house of the Rupa Sahani and thereafter we were brought to the Tezpur police station immediately.
No, what is the submission?
My submission, lordship, this is the local person, investigation is already over, informant has been already examined, lordship, there is no any chance of the tampering or hampering, lordship. So I may be allowed to go on, well, further custodial interrogation is not necessary, lordship. We will cooperate the trial, lordship. This is my submission and already 200.
Why the trial court rejected your prayer?
Yes, lordship. My rejection order, your lordship. There are two rejection, lordship.
Last rejection order.
Yes, last rejection lordship file that page number 42 lordship registered and the findings of the court is on the last paragraph, page number 42 last paragraph lordship. I have also perused the record. I also gone through the material collected by the IO and from the FIR and 83 of the BNS system of the VE, it is appeared that the accused committed aggravated parental sexual intercourse on the victim. Moreover, today the evidence of the victim is recorded from which it reveals there is sufficient inquiry material against the victim. This is the reasons, lordship. But in this case, lordship, charge sheet has been filed also after the 90 days, lordship. That is your lordship will find. Court's findings are there, lordship. Annexure F, lordship, page number, your lordship, find 29 and operating person, lordship. Yes. It starts from 29 and operating person, your lordship will find page number 32, second paragraph, lordship. Yes, lordship. May I read, lordship? Got it?
Yes.
Yes. In the instant case, it is seen that the charge sheet was
Yes,
received.
which page you are reading?
Page
Reading?
number 32, lordship, second paragraph.
Okay. Yes.
Yes. May I interrupt, Lordship? I'm sorry, Lordship. They are also seeking the ground of non-compliance of section 47/48. We can. It also.
It is there.
Yes, they have taken the plea, Lordship, regarding grounds of arrest. And apparently, Lordship, from the records, no such grounds were taken, Lordship.
Otherwise, suppose we leave upon the grounds of arrest.
Then, Lordship, there is a case.
No, victim has been examined.
Yes, only one victim. I'm sorry, Lordship, only the victim has been examined, but there are some witnesses, Lordship, who happen to be the mutual family members, Lordship. They have to be their important witness, Lordship, vital witness. Because on the night of occurrence, when she was taken back, Lordship, to their house, Lordship, they are the witnesses, Lordship, in the charge sheet also, Lordship. Lordship will also find the victim girl has also taken their names in her statement also, Lordship. So they are yet to be examined, Lordship. And yet apart, Lordship, on the last occasion, when one of the witness appeared before the court, Lordship, they sought an adjournment, Lordship.
They,
Sought an adjournment, Lordship. They took an adjournment. And so the witnesses,
okay,
one witness.
on grounds of arrest?
Grounds of arrest, Lordship, then they.
Yes.
Page number 19, not. Otherwise, the point which has been raised by my learned friend, charge sheet, the application for default bail was filed on the 91st day, and the charge sheet was also filed on the 91st day. So if there is no pending application for default bail, or the default bail application does not precede the charge sheet, my lord, then they do not have that indefeasible right. The right gets extinguished by the filing of the charge sheet.
But just to clarify, Lordship, the charge.
No,
sheet was-
suppose the charge sheet has been filed on 97th day. And there is no pending application.
Mohanlal Acharya as well as Ravindran.
So there has to be an application.
Application has to, they have to seek, they have to make themselves available to furnish bail. Otherwise, the right to default bail will not exist.
And as soon as it is filed, Lordship, his right gets extinguished, if there is no pending bail application.
My submission is, Lordship, that if 90 days or over as per
No, forget about 90 days now.
91 days, Lordship. Yes, we have to, but there is a right of the accused, Lordship, that he get the.
It is a settled law, Lordship.
Default bail, Lordship.
No, Apex Court
It says-
has clarified.
Yeah.
You are not pressing grounds of arrest, then we can dispose of this case.
Yes.
You are not pressing,
Yes, Lordship.
yes or no?
Yes, on that day we have not filed. On 90 days we have not pressed it.
On grounds of arrest.
No, yes, Lordship.
Pressing.
47, yes, I'm pressing. 47, page number 19, Lordship.
It is.
There is no ground of arrest, Lordship. And no
Okay.
notice in service.
Heard Mr. R. Burwa, learned counsel for the petitioner. Also heard Mr. DP, also heard Mr. B. Sharma, learned additional public prosecutor. As well as Mr. S. Nawaz, learned amicus curiae appearing for the respondent number 2. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely Shri Chakar Sahani alias Shankar Sahani, who has been detained behind the bars since 24/12/2024 in connection with special POCSO case number 2032/2025 under section 96 of BNS, read with section sections are
Sections are, Lordship,
96
96,
65(2).
slash 60
64, 1.
Charges were framed under 65(2).
65(2)
Read with section 4.
of BNS, read with section 4 of the POCSO Act. The gist of accusation in this case is that On 23/12/2024, the mother of the victim girl had lodged an affair that on 22/12/2024 at about 4:30 p.m. The minor daughter of the informant was kidnapped by the present petitioner, and whereabouts of the victim girl was not known till the date of filing the affair. Learned counsel for the petitioner has submitted that the charge sheet in this case was lodged on which date?
Here is written as 22/3/25, but in the court it is seen on 25/3/25.
22/3/2025. Learned counsel.
Sorry. It's 25/3/25.
25/3/2025. He submits that it was filed after the it was filed on the 92nd day of the 91st day of the lodging of the affair, and therefore he submits that the petitioner is entitled to get default bail. He also submits that in this case, in the aforesaid case, the charges have already been framed and the victim girl has also been examined, and therefore, how many witnesses are remaining?
11 PW.
And 10 more witnesses are yet to be examined. He submits that unless petitioner is released on bail, he may not be able to defend his case properly. Learned counsel for the petitioner has also submitted that the petitioner is also seeking bail on the ground of violation of his constitutional right guaranteed under Article 22(1) of the Constitution of India, inasmuch as though at the time of his arrest, notice under section 47 of BNSS was served on him, it does not contain any ground of arrest therein. Where is the notice?
What is page number, Lordship, 19? This is 47 notice, Lordship. And page number 20, Lordship. Under section 14.
Stop. On the other hand, learned additional public prosecutor has submitted that the victim girl has implicated the petitioner in the offense alleged against him in this case. He, however, fairly submits that the notice served on the petitioner under section 47 of BNSS does not contain any grounds of arrest therein. It only contains the police station case number as well as penal provision involved in the offense. Stop. Learned amicus curiae has also submitted similar to that of learned additional public prosecutor. He also submits that though in this case the charge sheet was laid on the 91st day, however, after the petitioner after lapse of the 90th day, no application for default bail was filed before the court, and same was filed only after filing of the charge sheet. And therefore, in view of, what is the case? Citation?
M. Ravindran is there, Uday Mohan Acharya is there. I'll give the citation.
Therefore, in view of the observation made by the apex court in the case of Uday Mohanlal Acharya, within bracket citation to Pisot Bharanibo, he is not entitled to get default bail. However, he also concedes that the notice served on the petitioner under section 47 of the BNSS does not contain the grounds of arrest therein. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the scanned copy of the case trial court records of scanned copy of the trial court records. Stop.
Uday Mohan Acharya is like 2001, 5 SCC 453.
Reported in 2001, 5 SCC, page number
453.
453.
2021, 2 SCC 480.
Write it. M. Ravindran, reported in
2021.
2021, 2 SCC 485. So, in this case, the petitioner has been detained behind the bars since 24/12/2024, and the victim girl has already been examined. Stop. Though this bail application has been filed on several grounds by the present petitioner. However, let us take the plea of the petitioner that no grounds of, let us examine the submission of the learned counsel for the petitioner that no grounds of arrest were furnished to the petitioner at the time of his arrest. On perusal of the notice under section 47 served on the petitioner, a copy of which is available in the case record, it appears that the said notice does not contain any ground of arrest therein. No basic facts which necessitated his arrest have been mentioned therein. Stop. The apex court in the case of which case? Not before that. Before that, Pankaj Bansal. In the case of Pankaj Bansal versus state of versus Union of India and others, reported in 2024 7 SCC 576, and thereafter in several other cases have observed that the furnishing of grounds of arrest, in writing, is the constitutional requirement of Article 22(1) of the Constitution of is the mandatory requirement under Article 22(1) of the Constitution of India. And any violation of the said requirement would render the arrest of the petitioner vitiated. Arrest of an arrestee itself illegal, in the instant case also, as no grounds of arrest were furnished to the petitioner at the time of his arrest, the petitioner is entitled to get bail in this case. The other contentions of the petitioners are not required to be discussed in view of the fact that he has been found entitled to get bail in this case. In view of above discussion, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the learned special judge
Sonipur.
Sonitpur with following conditions. Trial conditions, two trial conditions. Abhishek or Padu. This bail application is accordingly disposed of.
Deep level. 24 deep level.
My lord, may I please your lordship. Sorry to cause annoyance, my lord. With regard to item number 50 and 51, my lord, the date has been fixed as 12/8, my lord. I need some accommodation, my lord, either one day prior or one day later. In respect of item number 51, 50 and 51,
13 তারিখে পারিব 13 করে দিও Huh? 20 you are on interim,
one case I am here,
then let it be on 13. Item number
50 and 51.
item number 50 and 51 date reschedule করে
Right.
13 instead of the given date you give 13/8.
I'm obliged.
Yes,
The city was called for lordship, UPI lordship. Under section UPI.
yes there is there.
Today is 83 days, lord.
In this case, also the other co-accused bail, it has all been dealt by Mr. KK Parasar. Today he is not available, also. Also, can it be on Monday?
Monday. Okay. Let it be on Tuesday. Heard Mr. N. Ahmed, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that this case is dealt with by another additional public prosecutor, Mr. K.K. Das, who K.K. Parashar, who due to some personal difficulty is unable to attend the court today, and therefore he seeks some accommodation. The prayer is allowed. Let this case be listed on 5th of August.
Please, your lordship. Petitioner is 64 years old and he is an under trial prisoner, my lord. The allegations are under the POCSO Act and my lord, 3 witnesses have already been examined, including the victim and the father, the informant.
Since when you are behind the bars?
I am behind the bar since 25/10/2024. That amounts to around 280 days. And my lord, another contention of mine is that the grounds of arrest were not furnished to the accused person, that is the petitioner, my lord, and I have annexed the section 47 notice, your lordship, at page number 70.
Yes. It was not furnished. Heard Mr. S. Day, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, as well as Mr. S. Das, learned amicus curiae appearing for respondent number 2. Learned counsel for the petitioner. No, this application under section 483 of BNSS has been filed by the petitioner, namely Atul Khonikar, who has been detained behind the bars since 25/10/2024 in connection with special POCSO case number 45/2024, corresponding to Gaurisagar PS case number 21/2024 under section 64 of BNS, read with section 4 of POCSO Act 2012. Learned counsel for the petitioner has submitted that the petitioner is facing trial in the aforesaid case within bracket special POCSO case number 45/2024 before the court of learned. Which court?
Special Judge POCSO Sipsagan.
Special Judge Poxo Sivsagar. And he is a aged old man of 64 years of age. It is submitted by learned counsel for the petitioner that the prosecution side has in the meanwhile already examined how many witnesses? 3 witnesses, including the victim girl as well as the first informant. And therefore, now the petitioner may be released on bail so as to enable him to defend his case properly. He also submits that petitioner is also seeking bail on the ground of violation of his fundamental rights guaranteed under Article 22(1) of the Constitution of India. As when he was arrested, though notice under Section 47 of the BNSS was served on him, it did not contain any grounds of arrest or basic facts which necessitated his arrest in the case. So, on the other hand, learned additional public prosecutor as well as learned additional public prosecutor Mr. B. Sharma as well as learned amicus curiae Mr. S. Das have submitted that though there are incriminating materials against the present petitioners, as the victim girl had implicated him in the offense alleged in this case, however, they have fairly submitted that the notice served on the petitioner at the time of his arrest, notice served on the petitioner under Section 47 of the BNSS at the time of his arrest does not contain any ground of arrest. I have considered the submissions made by learned counsel for both sides and have gone through the scanned copy of the records of Special Poxo case number 24/2020, 45/2024. So, it appears from the record that the victim as well as the informant have already been examined by the trial court as prosecution witnesses. It also appears that though notice under Section 47 of BNS was served on the petitioner when he was arrested, it does not contain ground of arrest or basic facts which necessitated. Where is the notice?
Page number 17.
Which necessitated his arrest in the aforesaid case. As the apex court has observed in the case of Pankaj Bansal versus Union of India and others, reported in 2024 7 SCC 576 and many other cases thereafter, that any violation of the requirement and the mandatory requirement of Article 222 within bracket 1 of the Constitution of India of furnishing grounds of arrest, in writing, would render the arrest of an arrestee vitiated. And on that count, such an arrestee is entitled to get bail. Stop. Comma, and in the instant case also, the petitioner was not furnished with the grounds of arrest. Hence, he is entitled to get bail for violation of his fundamental rights guaranteed to him under Article 22(1) of the Constitution of India. So, in view of above, the above named petitioner is allowed to go on bail of rupees 50,000 with one surety of like amount, subject to the satisfaction of the learned special judge. Special judge Foxo Sipsagar with following conditions 1 and 2. This bail application is accordingly disposed.
Most obliged. My lord, may kindly come to page 14 of my page 14(1)(4). My lord, is there the last page in fact? Page 14(1)(4).
Yes, simply arrest memo.
Arrest, my lord will see the reasons for grounds of arrest. Your lordship has seen, my lord, it is provided.
Yes,
My lord, may kindly, my lord, may kindly see Provir Prokaisto, this para number 37.
okay.
There also some grounds of arrest are given, what Supreme Court has said on this. The grounds of arrest in para 37,
Whether notice under 47 was given or not.
that is just the page 30.
Is there any requirement of furnishing arrest memo to the an arrestee under
no.
35?
Now, my lord, they
No,
are
s-
providing notice under section 35, which is akin with section 50 of the erstwhile CRPC, my lord. Section
No notice under 47 was given.
47 notice they have given. This is the
Which
47,
one?
page number 14, sorry, 47 notice they have given, page 13, 1-3, nothing is there. 1-3 is 47.
Yes, when were you arrested?
I was arrested on, my lord, I was arrested on 29/10/24.
What is the contraband?
Uh, morphine,
How much?
1.12 kg.
And what is the status of the trial now?
The status of the trial now, my lord, it is at the stage of framing of charges. Now, my lord, I've seen page 14, my lord,
Yes,
the ground of arrest which they have given.
yes,
My lord will kindly compare it with Provir Prokaisto para number 37.
yes, these are not ground of arrest.
Yes, exactly replica. Noun, pronoun, preposition, conjunction, everything same. Not even my lord, it is very strange how identical these grounds of arrest can be.
No, but Prabir Purkasta says that these are reasons for arrest.
Or which will not satisfy the test of 22(1). That is precisely, my lord, my dear. Para 37, absolutely, my lord, covered. Because in Provir Prokaisto case also, my lord,
Where it says that reasons are different from grounds.
my lord will see this Provir Prokaisto, para 37. I have given that para, my lord. Para 37. My lord will see. The interpretation given by the learned single judge that the grounds of arrest were conveyed to the accused in writing.
Yes, yes, Mr. Das.
The lordship has seen.
What is there as it is in record, lordship? Here.
Okay, heard. Mr. M. Vishwas, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Sharwan Singh, who has been detained behind the bars since 29/10/2024 in connection with NDPS case number 17/2025 under section 21C of NDPS Act, which is presently pending before the Court of Learned Special Judge Hojai. Stop. The gist of accusation in this case is that, where is the FIR?
FIR, your lordship will find at page.
That on 29/10/2020 on
My lord, may see the gist of the FIR from para 3, page 3. That in short, I have given that. That is the gist of the FIR.
on 29/10/2024, para 3,
Page 3.
one Tapan Bashir, SI of police, SI of Railway Protection Force, not SI. One Tapan Bashir of Railway Protection Force had lodged an FIR before the officer in charge of GRPS Lumding Railway Station that during regular checking duty conducted in the which platform?
Conducted at platform, my lord. It was in fact, my lord, train,
Which police station? Which railway station?
railway station, my lord. Complainant that Tapan Bachcha along with staff conducted checking against the good by train on. It was inside the train at one. This is Rajdhani Express from Dimapur to Guwahati. During checking that.
Checking in
Ramding railway station.
checking at Lumding railway station in 12423 DN Rajdhani Express. 1.2 kgs of suspected morphine was recovered from the possession of the present petitioner.
It is 1.12.
1.12 kg of suspected morphine was recovered from the possession of the present petitioner. Learned counsel for the petitioner has submitted that the petitioner is seeking bail in this case mainly on the ground of violation of his fundamental rights guaranteed under Article 22(1) of the Constitution of India, inasmuch as no grounds of arrest were mentioned in the notice served on him at the time of his arrest under Section 47 of BNSS. Stop. He submits that in the said notice, apart from the police station case number as well as penal provision, no other information which constituting basic facts which necessitated his arrest were mentioned therein. He also submits that even in the arrest memo prepared under Section 35 of BNSS, only reasons for arrest which are formal in nature and which cannot be regarded as grounds of arrest were mentioned therein. He submits that the reasons for arrest are quite different from the grounds of arrest as clarified by the Apex Court in the case of Prabir Purkayastha versus State within bracket NCT of Delhi, reported in 2024 8 SCC 254, wherein it was observed as follows. Quote para 37 from the judgment. He therefore submits that in the instant case, the constitutional mandate of providing grounds of arrest, comma, in writing, comma, to the petitioner at the time of his arrest has not been followed, and therefore on that count itself, he is entitled to get bail in this case. On the other hand, learned additional public prosecutor, Mr. K. Das, has submitted that though this case involves contraband of commercial quantity, comma, however, comma, the notice under section 47 served on the petitioner, comma, a copy of which is available in the case record, does not indicate any grounds of arrest therein. He also submits that the arrest memo prepared at the time of the arrest of the petitioner contains reasons for arrest therein. Stop. I have considered the submissions made by learned counsel for both sides, and have gone through the records, scanned copy of the records of NDPS case number 17 within bracket H/2025. Stop. The apex court in the case of Prabir Purkayastha versus State within bracket NCT of Delhi within bracket Supra has observed that the grounds of arrest are to be furnished to the petitioner, to an arrestee, comma, in writing as soon as possible after his arrest, and any violation of the said requirement would be infringement of his fundamental right guaranteed under Article 22(1) of the Constitution of India. In the aforesaid case, the apex court has also distinguished between the phrases within inverted comma, reasons for arrest, and within inverted comma, grounds of arrest, as discussed in paragraph number dash herein before. Dash to piece of fill up kore. Stop. In the instant case, thus it appears that at the time of the arrest of the above named petitioner, though notice under section 47 was served on him, it is devoid of any grounds of arrest or any particulars which would indicate the basic facts which necessitated his arrest in the case. Thus, there has been a violation of constitutional right of the petitioner guaranteed under Article 22(1) of the Constitution of India. And on that count itself, the petitioner is entitled to get paid. For the reasons mentioned aforesaid, for the aforesaid reasons, the above named petitioner is allowed to go on bail of rupees. How much contraband?
1.12 kg.
How much it costs?
My lord, though I do this sort of cases.
You
but
must be knowing.
My lord, otherwise personally, I have no idea about all these things.
It is not believable.
Morphine, কিমান হয় morphine এর দাম? দেখাও নাকি?
1 lakh, 1 lakh.
Will be, my lord, will be on the higher side. Because these are Hojai, Shankardev never, my lord, whether there are people who will.
Quantity also huge, that also.
No, you have to assist the court to properly.
No, my lord, I leave it,
What would be the
Condition, I leave it. to-
cost of the
Condition, I leave
1
it to the-
kg of morphine in the international market. 1 lakh.
1 crore.
1 lakh with 2 sureties of like amount. Subject to the satisfaction of the learned special judge
Within bracket NDPS, Hojai at Shankar Dev Nagar.
Shankadev. With conditions, trial conditions, Abhishek or Puralobo. This bail application is accordingly disposed of.
I am deeply obliged, man. Next time I'll try to figure out what is the cost of.
Yes, you
all
may find.
this. Please, your lord.
Here we file our objection on 26/6, but which is not available on record. Lordship. On 26/6, Lordship.
26,
6, Lordship.
6, it's long ago.
Lordship, I have a copy of the objection. If your lordship requires, then lordship may peruse my.
You are otherwise ready.
Yes, I'm ready.
You are ready.
May please, your lordship.
কিন্তু খবর লোকসন objection দিও. You have an extra copy of that objection.
I don't know. I've gone through it.
Yes.
The accused person in this case was arrested on 5/4/21, 2021. As of today, he's behind the bar for the last 4 years, 3 months, 27
Last
days.
how many years?
4 years, 3 months, 27
What is the
days.
date of arrest?
5/4/2021. Here the allegation-
4 years, 3 months.
3 months, 27 days.
Okay.
Here the allegation was that the NCB received the secret information, and as per the information, they arrested 2 persons and from them seized 243.8 kg of ganja from their vehicle. The present petitioner was not present at the place of occurrence, and he was arrested merely on the statement of one of the co-accused. The search sheet was filed on 17/4/2020. And the search was framed on 2010/2022. 10 numbers of witnesses are there, and out of these witnesses, 4 witnesses has been cross-examined in this case. And your lordship has allowed the co-accused in this case has been allowed bail by your lordship.
What is the name?
One is Suraj Singh, Kajal Devnath, and Sandeep Singh. I have the orders. On the grounds of long incarceration, all the co-accused has been granted bail in this case. Except for the confessional statement, nothing is there in the search sheet.
Okay. What is your submission?
Bail was granted to co-accused, but they don't have criminal history, but he is involved in 4 cases. Currently, he is facing a lordship, he is involved in 4 cases, NCB crime number 16/2019 and NCB crime number 6/2020, NCB Guwahati lordship. And he is involved in NCB crime number 1220, NCB Patna, and NCB crime number 2/2019, NCB Patna.
In all
He is
these are
involved in 4 cases.
all these are allegations.
No, let her submit.
It
You
can-
can reply back,
it can-
but in the midst, if you reply, I will hear nothing.
It cannot be denied that his involvement is not there. His involvement is there, lordship. He is the receiver of the controversy.
These 4 cases, charge sheet have been submitted. In these 4 cases, he is facing trial.
The matter. NPS case is there, lordship. It is there in our objection, page number 79.
But so what is your submission?
It cannot be denied that involvement is not there, and
No, involvement is there, but in this case, there is a delay.
Bail was granted to one of the co-accused, namely Suraj Singh. He has jumped the bail lordship. So court is passing order and passing an NBWA lordship against him. So currently lordship,
Surat Singh has jumped bail.
status of the trial is production and appearance lordship. Court is passing NBW against him. So this is the status lordship. We have mentioned this in our objection. This is the reason of delay.
That is not only the delay. In the.
What is the assurance that you will not jump bail like Surat Singh?
For Suraj Singh, I cannot be punished. I will not, I'm not.
No, but
I,
he was your partner in crime.
Your lordship, not partner. He was, I think, he was the driver.
And there are 4 other cases against you.
And in all this, in Patna case, I've already been granted bail as per my instruction I've received. In Guwahati, there are 2 cases. I'm before your lordship. In these 2 cases, in both the cases, already I'm behind the bar for the last 4 years, 3 months. The prosecution got enough time to conclude the trial, but within this period, from the date of search frame, only 4 witnesses has come. Other witnesses has not been cross-examined. So there is a delay, your lordship. It is not a case that after Suraj Singh, the delay was there. Before he got the bail, before he jumped the bail, there was delay. And all the other co-accused has been granted bail before that period.
Whether Kajal Devnath is appearing.
Yes, lordship, he is appearing. He has 3 cases in Guwahati and he is appearing in all the 3 cases.
What is the assurance that you will appear
I will appear, lordship.
apart from your submission?
Yes, lordship. I will appear.
Heard Mr. J.K. Bhuya, learned counsel for the petitioner. Also heard Ms. M. Deka, learned counsel for NCB. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely Govind Shah, who has been detained behind the bars since 5/4/2021, within bracket, for more than 4 years, 3 months, bracket close, in connection with NDPS case number 32/2020, pending before the Court of London, Session Judge Kamrup Metro. So, the gist of accusation in this case, quote paragraph number 3 from bail application number 2591 dated 2591/2024 dated 18/11/24 flat করে দিছো ইয়ার প্রেসাইড কোড প্যারা 3 Learned counsel for the petitioner has submitted that the petitioner was not found in the conscious possession of the ganja which has been seized in this case. He submits that the petitioner has been arrested in this case only on the basis of the statement recorded by the co-accused persons. He also, you are relying on Tufan Singh.
Yes.
He also submits that in view of the ruling of the apex court in the case of Tufan Singh versus State of Tamil Nadu, reported in 2021, 4 SCC 1, the statement of co-accused recorded under section 67 of the NDPS Act is inadmissible as evidence in a trial involving offense under NDPS Act. He further submits that though the petitioner has been detained behind the bars for more than 4 years, 3 months, till date, only 4 out of 10 listed prosecution witnesses have been examined. And there is unlikelihood of trial getting culminated at the earliest. He also submits that how many co-accused have been granted bail? Two.
Three code.
3. He also submits that 3 co-accused have already been granted bail by this court on the ground of prolonged incarceration. Quote para 10 from the the earlier judgment. On the other hand, learned counsel for the NCB has vehemently opposed the grant of bail to the present petitioner and has submitted that the quantity of contraband involved in this case is of commercial quantity and therefore embargo of section 37 of the NDPS Act is applicable to this case. Stop. She also submits that the petitioner is a habitual offender dealing with the offenses involving NDPS Act. She submits that he has been involved in NCB crime number 16/2019, 6/2020, 12/2020, and 2/2019, correct? Is it right? 2/2019. And in view of the multiple cases pending against the petitioner, there is no assurance that he would not indulge in commission of similar offences again if he is released on bail at this stage. She also learned counsel for the NCB has also submitted that one of the co-accused, namely Suraj Singh, who was granted bail by this court on the ground of prolonged incarceration, has jumped bail and therefore trial is not progressing. She submits that if the petitioner is allowed to go on bail, there is also likelihood that he would evade the course of justice. Stop. I have considered the submissions made by learned counsel for both sides. On perusal of both sides and have gone through the scan copy of the records of special NDPS case number 32/2020. On perusal of the records of this case, it appears that the petitioner was not found at the spot when the seized contraband was recovered in this case, was recovered from the vehicle in this case. He has been implicated later on the basis of the statement made by the co-accused. Though it appears that there are 4 other cases pending against the petitioner involving offences under NDPS Act 1985, however, same may not be a ground for prolonging his incarceration in this case. Court para 21, 22. Twenty-three. 24. 26, 27. Time to change করে দিব instead of period of incarceration. Though one of the co-accused has jumped bail, however, that in itself may not be a ground for denying bail to the petitioner on the ground of prolonged incarceration, as another co-accused who was granted bail on the same ground is reported to be regularly appearing before the trial court. Twenty-eight. What is the contraband?
Your Lordship, ganja. 243.8 kg of gun.
30. 2 lakhs with 2 sureties of like amount. This bail application accordingly disposed.
Item 28. Your Lordship, item 28, same accused.
Same accused.
Here also he was arrested on 7/4/2021.
Any co-accused is there?
All the co-accused has been granted bail. The owner of the vehicle was granted anticipatory bail, and the annexer G, page number 72, and annexer H, page number 85 of my application.
Page number?
Page number 72.
70?
Apu Chatterjee, annexer G.
Apu Chatterjee is owner.
No, Lordship. Is one of the co-accused. And annexer H, Kajal, page number 85, that is accused Kajal Devnath.
What is the date of arrest in this case?
Date of arrest is 7/4/21.
What is the period?
Period is, your lordship, 4 years, 3 months, 25 days.
4 years, 3 months, same.
Same, 25 days.
Your objection remains same order.
Here,
Regarding delay lordship, their main ground is delay lordship. 3 witnesses have been examined
Out of,
out of 10.
10 witnesses.
instead of 4 witnesses, Mohammed, 3 witnesses. Baki eke thakibo. I will see the order. 2 lakhs with 2 sureties.
Mansoor.
May I please, your lordship? I was taken into custody on 18/3/25. The Yaba tablet is 2.97. And I was arrested while I was on trial of a truck brought out from the garage
Since when you are behind the bars?
from 18/3/25.
18/3/25.
Contraband is 2.97 Yaba tablets kg.
What is your contention?
My contention is that I was working as a garage mechanic, and I studied up to class 9, and I joined in the garage to maintain my family. I'm 18 years old. All this has come from the statement recorded by the special judge Kachar. I do not know under what provision he has recorded the statement. That also I have annexed. I'll show you. Then, my lord, it was found in the chamber of some white cloth person has appeared and said that we want to search your truck. He allowed and found that there was a chamber, and from that chamber all these contrabands were recovered.
Secret
But-
chamber.
Yes, inside the truck there was a chamber, and truck was not belongs to me. Garage is not belongs to me. All these things are yet to be investigated, in spite of the fact that I have disclosed in my statement before the special judge that I am a student. I stayed up to class 9
You were working in that.
garage as a mechanic. Now, the high important point of this case that 47/48 has not been complied.
47, where is that notice?
Yes, I am showing, my lord, kindly. From their affidavit, my lord, I think affidavit has come. Their affidavit has come in the record. CD also has come. Page 66 of their affidavit.
Page 66 of
Their affidavit.
their affidavit.
Yes. Now, and that is the annexure 1 filed by my learned friend from the
66 is a
Director of Revenue Village.
certificate.
Yes, to whom it may concern.
What is this?
The arrestee, Sri Jitan Ahmed Lashkar, date of birth is 2006, son of Omut, Khadija Part Kachar, Assam, has informed his father, Sri Asabuddin Lashkar, over telephone from telephone number such. What informed? What has given telephonic informed to my father? How it will comply 47? Your lordship has
Where
done.
is 47?
Yes,
This purports to be 48 notice.
yes. The next page kindly, next page. Next page, this is 48, 6, 7. Subhanando Police Kachar, subject to intimation of arrest regarding, with reference to subject mentioned above, this is to inform you that office has seized 2.97 kg suspected methamphetamine Yaba tablets from a 4-wheeler Mahindra Bolero bearing registration number such. The occupant, immediate possessor of the contraband drugs in the vehicle as detailed below, was arrested under provision of NDPS Act on 19/3/25. A copy of the arrest memo is enclosed herewith. The family members of the arrestee as per the following address may kindly be intimated accordingly. It was directed to the SP, Superintendent of Police Kachar. You please intimate his family that he has been arrested. Under what ground? There is nothing. Nothing. Only Jitan Ahmed 18 years as per the Aadhaar card. This is the intimation. So your lordship has just decided several cases. I was observing, my lord, referring to the apex court decision. And my lord, whether these two are amount to a compliance of Article 21 of the Constitution of India. Whether this judgment referred by these two judgments, one is my lord, Bihan Kumar.
Where is 48 notice?
My lord, page number 75. This is enclosure of page number 69. Page number 69 is my learned senior has read only the one part of the letter.
Yes,
The
arrest
arrest
memo.
memo is enclosed here. Arrest memo is a detailed arrest memo with all everything matter. Entire incident, even the description, entire description of the accused has been made there. And this arrest memo has been received by the accused person.
Where is the receipt?
This the signature is there. On the bottom line, Jatin Ahmed Loskar. 19/3/2025.
Where?
Yes, page
At
76.
75, my lord.
Page number 76, signature, though in both page signature.
Page number?
75.
75, below my lord, Jitan Ahmed.
Below, my lord.
Just a minute.
Whether it is amount to,
This is a type copy, my lord. Initially, it's a type copy. 70 is a type copy. This is 75 at the bottom. Jatin Ahmed Loskar in both pages. In 76, now this was signed by even in presence of the witnesses.
This 75 is what, which notice? 47 notice.
Yes, my
It cannot be.
arrest memo, my lord.
arrest memo.
But they have not technically identified which one is 77, 47 or 40.
No, that is your duty as arresting
Yes,
authority.
arrest also, it is their duty, my lord, but it was mere my lord, disclosure provision does not make it invalid, my lord.
No,
That it
this
has
will
to be
not
the-
make invalid, but you have to at least inform the court which purports to be 47 notice and which is the notice to relatives.
69 is the notice to relatives. It is sent through the SP. It encloses with the arrest memo, with a copy of the arrest memo. If you also can kindly go to page 69 and it's a B, it says
No, to whom it was sent?
to
69.
the SP.
No, you have to send it to
Family.
the either the friends or relative, or if friends or relatives are not there, to a nominated person nominated by the arrestee. You have to ask him, whom do you nominate, to whom, which?
Actually, the information was given by phone to his father and the letter was sent to his father through the SP.
Which
through the
letter?
police. This NSS 69 was sent to the father, is marked to the father through the SP. It's written that the family members of the arrestee person as per following orders may kindly be intimated
No,
accordingly.
this notice is only to SP.
Yes,
Where is the notice to the relatives?
that is not there.
That is the requirement under 48 Vihan Kumar judgment of Justice N. Koteshwar Singh.
No, this notice, in fact, was sent to his father through the police. That's the thing, but directly it was not sent to the father.
No, even if it is through the police, it is sent through the police. You have to satisfy the court. It is on perusal of this notice, it appears that it was sent to superintendent of police. He was asked to send the notice to,
the father.
it is not notice to his father, it is notice to a letter to superintendent. You show a notice, written notice to the relatives. My simple query is whether 48 was complied with.
If sending directly to the notice, my lord, I have to take instruction, otherwise, my lord, the case diary is there, scan copy is there.
You show me, you go through the case diary. Give him the,
Yes,
case.
yes.
You take some time, we'll take it up after some time.
My lord.
You point out which is the notice under section 48. Record to the. You can go through the records also.
Maybe, Lordship. Lordship, last year, the learned additional PP to take information regarding whether the notice was served or not upon the respondent number 2.
It has been served, lordship. My question will be appointed.
Suggest one amicus. Any amicus present in the court? Please take one. Heard Mr. B. Islam, A. Alam, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that notice issued to respondent number 2 has been served. He also submits that an amicus may be appointed for defending the cause of respondent number 2 in this case. According, this court also intends to appoint one amicus to defend the cause of respondent number 2. Accordingly, Srimati Bernita Chaudhary is hereby appointed as amicus curiae to defend the cause of respondent number 2 in this case. The petitioner is directed to furnish copies of bail application along with annexures to the newly appointed amicus within 2 days from the date of this order. The registry to reflect the name of amicus curiae in the cause list henceforth list this case again on 19th.
What's it, May it fix before 11?
11th. On 11th.
If published.
31.
Okay, we are.
Yes.
I'm for last 2.5 years, I'm behind the bar. Out of 5 witnesses who were arrested on the basis of statement of prime witnesses, 4 of them were allowed to go on bail on. I have annexed the order.
Today is the second date.
Today is the second date. I have filed this on this case 1/7/25, almost a month. They did not file any objection. Now
You
today.
should have prayed for filing objection earlier.
Officer, personal duty, Lordship, that is well achieved.
Similar situation.
When will you file?
Tuesday.
Similarly situated persons were
Okay.
released on.
No,
bail
she is
in
seeking a
March.
very
No, not-
short time.
not-
Mr.
Judge.
Z. Mr. Z. Alam, learned counsel for the petitioner. Also had Ms. M. Deka, learned counsel for NCB, who prays for some more time for filing written objection against the prayer for bail filed by the petitioner. The prayer is allowed. Let this case be listed on 11th.
Highly obliged.
Item 32.
May I please? Malad, this is regular bill application, Malad, 60 days offense, Malad. I am behind the bars since 57 days. The offending post has already been seized, Malad. So, Malad, kindly consider the length of detention.
What is the offense?
Malad, allegation is under section Malad 196 to 99, 302, 351, 352, 353. BNS reduced section 67 IPI.
No, what you have done?
There was Instagram ID, Malad, sitting in the majority class of the county, Malad. That is, Lordship will find it at page 15, forwarding. Lordship will kindly turn to page 16, Lordship, paragraph number 6.
What is your submission?
It is only 3 days. Kindly
No,
consider.
regarding the acquisition.
My lord, that video, original video was created by someone else. Here in this case, his lips was my lord come. I am not the creator of the original video.
Out of anger.
My lord.
What is the progress?
Lordship, the IP address has been traced back to him, Lordship. So everything is there, Lordship.
Heard. Mr. A. Paramanik, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner Saniur Rahman, who has been detained behind the bars since 6/6/2025 within bracket for last 57 days in connection with BOCO PS case number 194/2025 under section 196 within bracket 1/2/302/351 within bracket 3/352/353 within bracket 1 of BNS, read with section 67 of the Information Technology Act. The gist of acquisition in this case is that the petition that on 6/6/2025, one Bitopan Rajbanshi has lodged an FIR before the officer in charge of BOCO police station, inter alia, alleging that from the account handle, Instagram account handle of the present petitioner, an objectionable video was uploaded therein, whereby the people of Hindu community were threatened. Stop. Learned. Next para. Learned counsel for the petitioner has submitted that the petitioner has been languishing behind the bars for last 57 days, and the maximum statutory period of detention in this case under section 487 of the BNSS is 60 days only. Hence, considering the period of detention already undergone, he may be allowed to go on bail. The petitioner may be allowed to go on bail. Stop. On the other hand, learned additional public prosecutor has produced the case diary and has submitted that there are sufficient incriminating material against the petitioner in the case diary. He also submits, however, that the investigation has fairly progressed in this case. I have considered the submissions made by learned counsel for both sides and have gone through the case diary produced by the learned additional public prosecutor staff. Though there are incriminating materials against the petitioner in the case diary, however, considering the progress made in the investigation and period of detention undergone by the petitioner, this court is of opinion that further custodial detention of the petitioner may not be necessary for fair completion of the investigation of the aforesaid case. Stop. In view of above, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Judicial Magistrate First Class, Boko, with following conditions, number 1 and number 2. Send back the case diary. This bail application is accordingly disposed of.
Item 29.
So I said, you have gone through.
It's not there, man. It's not there. Only thing, my lord, that their notice has been sent to the father for the SP. That is this is the only letter I have in the case diary. Otherwise, it was not sent directly to the family members.
No, even if it is sent indirectly,
Yeah.
there has to be some proof of sending.
The postal receipt is there, speed post receipt. That with the SP, postal receipt is there, they have enclosed there. But if a lordship is intending that it is whether it is sent directly, then it's not there. In page
No,
number-
what was sent?
Page number 69 of my affidavit, in the bottom there is a postal receipt is there, speed post receipt. It was sent on 23/2025.
No, where is the copy to show that this was sent? What you have sent in the post, in the letter which you have posted? What was sent? Postal receipt only shows that something was sent.
Yeah, that
But
part
what was there in the envelope?
envelope
A
is
copy
there.
of,
The copy is at page, this annexes page number 69 and other with arrest memo is there.
page number 69 was sent.
Yes, sent along with the arrest memo.
Then that is.
So whether it will amount to compliance of 48 or
And regarding on merit, that he was an employee of,
well, these are of all the manipulated stories. No? He was never there. The report is there in page number 47. I have in the affidavit I state the statement 46. The workshop which we said AK Motors works in city of Sonai Road never exists.
okay,
No such
where
workshop.
he was found?
He was arrested. We appeared with the vehicle.
He was driving the vehicle.
Yeah, he was driving the vehicle, and the vehicle owner, is in prison for he's in custody from I think in he's in custody in NDPS case, and this accused mother is also there. They are all involved, and the wife of this at. In page 47, it is written that a field investigation at the accused native place revealed that he's locally known as Hassan Ahmed Laskar.
Where are you reading?
Page 47, the third paragraph. Page 40, third paragraph.
Yes.
That a field investigation at the accused native place revealed that his locality known as Hassan Ahmed Laskar, alias Bachchan, and not by the name Jatin Ahmed Laskar. His mother, Surija Begum Laskar, alias Siroja Begum Laskar, is also booked in a drug-related case. The field visit to the house of the registered owner of the vehicle, seized vehicle, Mr. Faisal Ahmed Laskar, revealed that he is presently lodged in District Prison West Jaintia Hills, Meghalaya, in connection with terms of PS case number under Section 21B. And 29 NDPS Act. And his wife said that the vehicle was given to the mother of the accused. So entire family is involved in drug trafficking. My lord. And he just arrested recently. It's premature to grant him bail at this stage.
Where is the FIR? Let us go.
Okay.
Initial. Com-
21 page, kindly complain, 36A. Page 21. All these things submitted by my friend from the affidavit are not in the record.
Where he was found?
On the road out in front of the garage, while he was on trial of the vehicle.
That is your story.
Well, that is the story. Kindly peruse the statement recorded by the special
In
judge.
page number 22 of his petition, my lord. Page number 22, paragraph 1, it states, wait, my lord. That acting on a specific intelligence shared by DRI Guwahati Zonal Unit, the officers of Directorate of Revenue Intelligence, Silchar Sub-Regional Unit, Silchar, along with 2 independent witnesses and with assistance of Customs Silchar and Assam Rifles 38 Unit, Silchar, identified and intercepted one 4-wheeler Mahindra Bolero bearing registration number so-and-so at around 2100 hours on 18th 2025 near Bhaga Bajar area of Kachar district, Assam, who was just coming from Silchar, Mizoram,
Okay.
Sairang, Mizoram, wherein he driving the said car, identified himself as Jatin Ahmed Laskar. It was not a DRI who only intercepted, this Assam Rifles personnel were also there.
Heard Mr. S.C. Vishwas, learned counsel for the petitioner.
Well, 47 also has not been compliant.
47 has been complied.
My kindly peruse this 47 documents. From
Page,
my friend's record. That is page 66, madam. To whom it may concern.
no, that is not 47.
It's just an interim, that's a.
Then there is no other matter.
That's
There is no
just
other
a
document.
proof that he has been allowed to call his father.
There is
That
no
he's
other
arrested.
documents.
Which is the 47 document?
Not there.
No, there's no separate 47 or 48. they are
No,
not,
which is
but
the notice which you are saying that was given?
Even 69, page number 6, Annex B.
Intimation of arrest. That is Subarnapur Police.
No, they have clubbed 47, 48 together.
No, I am not club brother. It is
No,
not.
no, no, I'm not, no.
Oh, I
Not,
see.
I'm not telling you.
No, in page 69, which you are saying that it is notice to the petitioner. Where is the signatures?
Well, in page 69, that is not
There is
there,
no
but it
signature.
is in the arrest memo, there is there. The arrest memo was given to him,
Where is the
There
arrest
complete
memo?
different.
page number 75.
You are saying that the grounds were communicated by in arrest memo.
Yes.
Okay.
Can it be, my lord?
No. Sometime it may be if it is
Yes.
communicated.
My lord, Pravir Kumar judgment, your lordship just indicated, my lord.
Okay, okay. Dear Prabir Kumar. Kelly, huh? This application under section 483 of BNSS has been filed by the petitioner, namely Jitan Ahmed Laskar, who is who has been detained behind bars since, what is the date of your arrest?
18/3/25.
18/3/2020.
They said it is 19/3. 19/3.
Since 18/3/2025, in connection with DRI case number 8/CL/DRI/SIL/2024-25 under section 21C
Yes.
/29 of the NDPS Act 1983. The gist of accusation in this case is that acting on a specific information shared by the officers of DRI Zonal Unit, the officials of DRI, along with the assistance of Customs, Silchar and Assam Rifles 38 units Silchar, intercepted one four-wheeler Mahindra Bolero vehicle bearing registration number AS 11J9160 on 18/8/2025 near Bagha Bazaar area of Kachar district. The petitioner was found driving the said vehicle. Stop. On search of the said vehicle, in specially designed cavities under the rear seat of the vehicle, 6 rectangular packets were recovered, and from those packets, Yaba tablet containing methamphetamine weighing about 2.97 kgs were recovered therefrom. Stop. Learned Mr. S.C. Bishwas, learned counsel for the petitioner, has submitted that petitioner is a 18-year-old young boy and working in a garage. Which garage? What is the name of your garage?
AK Traders, man, go have not mentioned.
What is the name?
AK Traders.
AK Motor Works.
Yes, AK Motor Works.
AK Motor Works.
You should be knowing the name at least. Working in the garage. Messrs. AK Motor Works. He submits that the petitioner was
On trial of
driving the vehicle on trial after same was repaired. He also submits that the petitioner is not the owner of the vehicle, and he was not aware about the fact that the recovered contraband were concealed in the cavity below the rear seat of the said vehicle. he submits that as petitioner was unaware about the fact that the vehicle which he was driving contains contraband seized from therefrom, he cannot be regarded as having conscious possession of the said contraband. Learned counsel for the petitioner, next para, learned counsel for the petitioner has further submitted that in the instant case, the fundamental rights of the petitioner guaranteed under Article 22(1) of the Constitution of India has also been violated, inasmuch as the no notice under Section 47 of BNS was furnished to him. Neither his relative or / friend / nominated person were communicated about the grounds of arrest by serving them notice under Section 48 of BNS. He therefore submits that on the ground of violation of the fundamental rights of the petitioner guaranteed under Article 22(1) of the Constitution of India, he is entitled to get bail in this case. On the other hand, learned, what is your name?
MK Boro, madam.
On the other hand, Mr. M.K. Boro, learned standing counsel, DRI, has vehemently opposed the grant of the bail to the petitioner on the ground that the petitioner was found in conscious possession of the contraband which was recovered from the vehicle which he was driving before it was intercepted by the officials of DRI. Stop. He further submits that the submission of learned counsel for the petitioner that the petitioner is an employee of a garage, namely Messrs. AK Motor Works, are not true, as during the field verification by the officials of the DRI, it was found that the said story has been falsely projected by the petitioner only to get bail in this case. No such No, you found AK Motors, Mr. Boro.
No, madam, AK Motors not found, madam. In the same third period is written, on the field visit, the investigating officer, no such workshop we traced out the locality.
No. During field visit, no such workshop could be located in the vicinity.
It was AS Auto Works was found.
However, one Messrs. AS Auto Works was found there. It is also submitted that the owner of the vehicle was found. Registered owner of the vehicle, Mr. Faisal Ahmed Laskar, was also found to have been lodged in District Jail, West Jaintia Hills, Meghalaya, in connection with an NDPS case. He further submits that even mother of the petitioner, namely Srimati Surija Begum Laskar, alias Siroza Begum Laskar, was also found to be involved in offense under NDPS Act. Stop. Learned Standing Council, DRI, has also submitted that after the arrest of the petitioner, the grounds of arrest were stated in the arrest memo, which was prepared at the time of arrest of the petitioner. The said arrest memo has been annexed as Annexure C along with the written objection submitted by the petitioner submitted by the DRI in this case. He submits that the said arrest memo was forwarded to the Superintendent of Police, Cachar District. Who forwarded it?
Well, the seizing officer.
By the seizing officer on 13/9/2025, on 19/3/2025. Wherein a request was made to communicate the same to the family members of the arrestee. Where is the postal receipt?
What I just said, it is the copy has been attached with this.
Page 69.
Page 69 on the bottom, my lord.
But 69 only shows that it was sent to SP, not to the relatives.
No, it was sent to the SP only, not to the relative.
You don't have anything to show.
No, my lord, I don't have. It's not there.
Yes.
We have not sent it back.
Stop. Learned Standing Council DRI therefore submits that there has been a compliance of Vihan Kumar Dioksu, Putul, compliance of the requirements of furnishing grounds of arrest in writing to the relatives / family members / nominated person of the arrestee as mandated by the Apex Court in the case of Vihan Kumar versus State of Haryana, reported in 2025 5 SCC 799. Stop. I have considered the submissions made by Learned Council for both sides. As the petitioner is seeking bail in this case, also on the ground of violation of his constitutional rights under Article 22 within bracket 1 of the Constitution of India. Hence, before considering the case on merits, let us consider these submissions let us consider as to whether the submissions made by learned counsel for the petitioners are tenable so as to entitle the petitioner to get bail in this case. It appears from the arrest memo which was prepared on the date of the arrest of the petitioner, that is
19-3.
19/3/2025, Agotji to 18/3 date this say, make it 19th. 19/3/2025, on which the signatures of the petitioner appears. Though in the arrest memo, there is no specific mention that same is notice under section 47 of the BNSS. However, on perusal of the arrest memo, said arrest memo, it appears that it does contain the basic facts which necessitated the arrest of the petitioner in connection with this case, in connection with the above mentioned case. Stop. Therefore, if it is regarded that the petitioner was, therefore, as the signatures of the petitioner appears in the said arrest memo, it can be regarded that there is substantial compliance of the requirement of section 47 as well as section 22(1), in as much as furnishing the grounds of arrest in writing, to the arrestee is concerned in this case. Stop. However, in the case of Vihan Kumar versus State of Haryana and another within bracket Supra, the apex court has also observed that there is also a mandate under Article 22(1) of the Constitution of India to communicate the grounds of arrest, in writing, to the friends, relatives, or such other persons as may be disclosed or nominated by the arrested person. At the time of his arrest. In the instant case, on perusal of the case diary which has been produced by Learned Standing Counsel DRI, as it appears that though the arrest memo and intimation of arrest and a letter requesting that letter to the Superintendent of Police by the seizing officer requesting him to communicate the grounds of arrest to the father of the arrestee was made on 19/3/2025. However, there is nothing on record to indicate that said communication was actually made by the arresting authority or by the Superintendent of Police Kachar. Even Learned Standing Council DRI failed to show anything to satisfy this court that such a communication was in fact sent to the relative slash friend slash nominated person of the arrestee in this case. Thus, though there has been complaints of furnishing grounds of arrest in this case to the arrestee, however, there is violation of the requirement of furnishing or requirement of communicating said grounds, in writing to the relatives or such to the friends, relatives or such other person as may be disclosed or nominated by arrested person in this case. And this court is of considered opinion that same is in violation, also is in violation of the observations made by the apex court in the case of Vihan Kumar versus State of Haryana and another within bracket Supra. This court is of considered opinion, is therefore of the considered opinion that the petitioner is entitled to get bail due to violation of his constitutional rights guaranteed under Article 22(1) of the Constitution of India. The petitioner is accordingly allowed to go on bail of rupees 50,000 with one surety of like amount.
The cost of seized goods are 2 crore 97 lakhs.
Maybe he's 18 years boy, you must consider his age.
And
Maybe even
no,
minor also.
no, whatever it is, he has a trafficking the drugs, it's a different
You
thing.
have made the trap.
Yes,
That's the problem.
yes, my lord, I just one prayer, my lord. An observation may be made that, my lord, the sending a notice through the SP that will not means it is not the compliance of 88, it should be sent directly to the
No.
with the observation.
Need not be sent directly. Eta para likhibo. Though in this case, it appears that the notice meant for the father of the arrestee was sent to the Superintendent of Police, Kachar. However, there is nothing on record to indicate that same was in fact sent to the father of the accused person.
For that one, I have to take instruction for the Kachar police, my lord, because it is the Kachar police who will deliver it.
No, but there has to be something in the,
We can only provide the postal receipt, my lord, because it's.
but postal receipt is only to Kachar police.
Yes, my lord. And then Kachar police will deliver to that. So for that, we have to take instruction. of
That
Kachar
has to be kept in the case diary.
And let the matter come up next week. I will take instruction from the Kachar police then, my lord.
Court has concluded the judgment.
My learned friend will know because he is the person recipient of the letter. But he will not disclose.
How
today.
can we have not received, that's what we are saying. But it is, like, with all folded palm I am submitting, it is the
Wait.
responsibility of.
इसमें
arresting authority.
पैरा और ऐड करना है. With 1 lakh with two of rupees 1 lakh with two sureties.
Small boy, but if the amount to rejection will.
No.
Kindly make it 50,000. I undertake that he will never do these things, madam. Everything will reveal in the trial, madam. He is innocent boy.
My learned, if I can give in writing, I can give like a PR bond also.
But-
They will not do it again.
Yes, we are assuring people
Their
to go.
families in the.
This is your people are trapping all.
1 lakh with 2 sureties.
My lord.
My lord, it may be
One
too late.
surety, my lord, it will be difficult for him out, my lord. Your lordship know apex court judgment also and our own high court judgment. regarding-
You know the law when the grounds, when the condition become onerous, what is to be done later on?
Question is that your lordship has considered the bail. If your amount is too, my lord, high, how he will come up? That is the, we have to arrange.
Considering
1
the-
lakh, I agree.
Consider,
With 1 lakh, surely, one surety.
if you insist, I will reject the bail.
No, my lord, then I not insist. Then you have to rot inside the jail. That's the problem.
I will address your concern that it was sent to the Kachar police and it will only be known by the Kachar police whether it was sent or not. But as on date, there is nothing on record to indicate that it was actually sent or not.
Yes, sir.
What the police has to do in such cases, I will make observation later on in the. I will have to modify a little bit,
My lord,
All right.
but the bail order remains.
my lord, but the thing is, this is a commercial quantity.
1 lakh with 2 sureties of like amount.
But only thing is, it is academic, well, academic, not a part of this.
Later on, some other day.
All right.
33.
This is charge sheet submitted.
Charge sheet submitted.
Right.
You appear before the trial court. Heard Mr. A.W. Aman, learned counsel for the petitioner. Also heard Mr. D.P. Goswami, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid. Considering the fact that charge sheet has been submitted, this bail application is disposed of with an observation that the petitioner may approach the trial court and may pray for regular bail before the said court, if so advised.
34.
Wait, please, your lordship. I think regular bail application, lordship. Sections involved are 420 and 409 of the IPC. And the petitioner is in custody since last 51 days. And lordship may kindly see the FIR at page number 13. 13. May I read the FIR?
Yes.
With due respect, I would like to state that I am the owner of a plot of land measuring so and so, situated at Gelapokuri Gaon under Rongagora Moza within Tinsukia Revenue Circle in the district of Tinsukia, Assam. In the year 2018, I approached branch manager of Oriental Bank of Commerce Tinsukia branch and requested him for housing loan of rupees 10 lakh for the purpose of constructing one RCC building over my said plot of land. The then bank manager, Sri Amit Kumar Jha, he is the main accused lordship. Amit Kumar Jha stated the process of sanction of loan and asked me to submit the original documents, that is sale deed, Jamabandi land revenue receipt, cadastral map, trace map, and other related documents of my land. The said bank manager also took my signatures on various documents which I was never allowed to read. After the due process, the bank manager asked me to come after 1 month and assured that loan amount will be credited to my account. After 1 month, I visited the bank on several occasions, but the bank manager on each and every occasion failed to credit loan in my account. The manager kept on assuring me that the matter is under process and it will take some time for the credit of the loan. After that, in due course of time, I became frustrated and left all hopes to get any amount of loan from the bank, and due to my involvement in some business, I could not approach the bank manager frequently for any update regarding sanction of loan in my name. Thereafter, suddenly on 12/11/2019, I received one notice under section 13(2) of the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, issued from the Oriental Bank of Commerce Circle Office, Guwahati, stating that I stood as personal guarantor of MS PS Trading account number so and so, along with Mr. Anand Rasivasiya. He is the petitioner hearing, Anand Rasivasiya, of DM Lohia Road, College Road,
Tinsukia, and the said MFBS Trading has taken a loan of rupees 50 lakh only. The said loan account turned NPA and at present rupees 24,28,827.70 is due, and the bank will auction my plot of land of if liability of rupees so and so is not discharged. I, being very surprised, inquired the matter and came to know that the bank manager Sri Amit Kumar Jha dishonestly and illegally used original documents on my land and of my land and the documents having my signatures and made myself as guarantor of MS so and so, account number so and so, without my knowledge and consent. I therefore request you to kindly look into the matter and take necessary action against the bank manager Sri Amit Kumar Jha, who is presently working at Circle Office Guwahati MC Road near St. Mary's School, Guwahati 781003. This is the FIR lodged in the year 2020. And the entire allegation revolves around this bank manager Amit Kumar Jha, Lordship. And thereafter, Lordship, what happened, Lordship, in 2022, the investigation returned into Lordship final report. Lordship will find at page number 15. Then, Lordship, the informant objected to the final report, and on his objection, the court below has directed for Lordship fresh investigation. Lordship will find at page number 17. Fresh investigation was ordered by the court below, Lordship.
Fresh investigation.
Fresh investigation, Lordship, page number 17. Then some different IO was appointed, Lordship. And thereafter, Lordship, this Lordship, FIR name accused, Lordship, that the bank manager has, Lordship, got pre-arrest bail from this honorable court, Lordship. Lordship will find at page number 24. Initially, he was granted the privilege of interim pre-arrest bail, and later on the same was made absolute. The final order is, Lordship, at page number 26.
Yes.
Then this person was, Lordship, arrested from UP on, Lordship, 12th of June, and he was brought to Lordship Tinsukia. And since then, he is in custody for last 51 days. And Lordship, when the main accused, the bank manager has,
Amit Jha is,
Lordship,
Amit Jha is
Amit Jha is that Lordship,
on
bank
bail.
manager. He is on pre-arrest bail, Lordship.
Okay.
The main accused, Lordship. And this
Yes.
person, Lordship, 51 days in custody, Lordship, 409 is not affected because he's not employed with the bank, or he is not also he is not an agent, Lordship.
You were the guarantor only.
Guarantor made by the Lordship, that bank manager. I was also made as a guarantor along with him, the informant. If
Yes.
409 is wiped out, Lordship, 60 days is the period, Lordship, 420, Lordship, at best.
Yes, Mr.
Your Lordship, the main conspirator is the present petitioner, Lordship. In the year, Lordship, 2019, when this person, the informant, he approached the bank for a loan, Lordship. Through him, Lordship. He facilitated that he will be providing the loan, Lordship.
To
Therefore,
the informant.
to the informant, yes. Now, what has happened, Lordship, their Lordship, with the collusion with the then manager of the Oriental Beckham Insurance, the account was opened in the name of one MS Trading, and 50 lakhs was loan was taken, Lordship. Thereafter, Lordship, he fled away from Tinsukia, Lordship, in the year 2019. And thereafter, Lordship, he was arrested in 2025 in the month of June only, Lordship. For all these years, he was living in Meerut, UP on a different name, Lordship. That Lordship will find at page 18. If Lordship kindly comes to page 18. This is the transit remand and prayer, Lordship, for police remand. Relevant portion, Lordship, will find at page 19.
Yes.
Page 19, Lordship, I will skip this part, Lordship. Lordship will kindly come to in due course. In due course of investigation, the below noted arrested accused person has been found absconding since October 2019, prior to the registration of the case, and he permanently shifted his location from Tinsukia, as the bank authority has already taken possession of his immovable property, land property in his house. As soon as the loan was sanctioned, Lordship, he fled away from Tinsukia, Lordship. Since he was the mastermind of the case and misappropriated more than 20 crores of money from various nationalized banks. Not only this, Lordship, The IO has stated that there are various debt in his name also, Lordship. His whereabout was necessary and using human intelligence as well as technical data, the below noted accused person was traced at Meerut, where he has been running his business as MS Shivam International, basically dealing in tea supply from Siliguri in the name of one Anil Kumar. He had changed his name also, Lordship. Whereas the below noted accused person never his name as well as the name of his family members with a view to conceal their identity, and finally he was arrested by a team of Tinsukia police station led by Sonia. Thereafter, Lordship will find point number Lordship 4. Just to illustrate Lordship how he has been operating there, his custodial interrogation is necessary to find the transformation of Anand Rasi Wasia, he is the name of the present petitioner Lordship, to Shivam Agarwal. He changed his identity Lordship, as he was operating his business in the name and style of Shivam International and introduced himself as Meerut as Shivam Agarwal. So that is the case, Lordship. Now, Lordship, the amount is yet to be recovered, Lordship. And other
That is,
aspect
Lordship,
of the case, Lordship, is that investigation is still going on, Lordship, and he is a flight risk, Lordship. He has once disappeared in the year 2019, Lordship. Then he was arrested in 2025. In the month of June, he was produced from Meerut.
This is a 90 days offense.
Yes, Lordship.
Lordship, then his that note by the IO was at the time of seeking his remand. Now he is in custody for 51 days. He has been thoroughly interrogated. And this FIR finally, Lordship, before returned to final report, Lordship. And after objection of the informant, after hearing the informant, the court below ordered fresh investigation. So he fled away in 2019 before the registration of the FIR. And the main accused, Lordship, who is the bank manager, he has got the privilege of pre as well, Lordship. He is on pre as well, Lordship. And this person is not a bank employee. So 409 will not come into play. 420 at best, Lordship, if any. And Lordship,
But
51 days.
the accusation that you have changed your name in Meerut.
That, Lordship, the IO has got sufficient time, 51 days in custody, Lordship.
No, what is your submission?
That is that I deny, Lordship. 51 day, Lordship, that change of identity.
Lordship, the FIR was lost once the informant received the notice from the bank, Lordship. So he could not have lodged the FIR prior to that. But since the loan was sanctioned, Lordship, he escaped from here. So his intention was very clear, Lordship. He did not wait for the account to be piled up, Lordship.
You need further custodial
Yes,
interrogation.
51 days,
It is a
Lordship.
flight risk, Lordship.
51 days. And
Yes,
I have
definitely a
given the
flight
address,
risk.
Lordship. He is the resident of Tinsukia, Lordship.
It is definitely a flight
And
risk.
Lordship, considering the fact that the main accused, Lordship, who is the
You-
bank manager who used all the documents, he sanctioned the loan, Lordship, 50 lakh. He has made me a guarantor.
Lordship, what
as
has
well as the
transpired from the case that Lordship, the bank manager got 5 lakhs rupees from the present petitioner, Lordship.
That is it.
The main mastermind is the present petitioner, Lordship.
But the without the authority of the bank manager, the loan could not have been, Lordship.
Heard
sanctioned.
Mr. N. Hassan, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Anand Rasi Wasia, who has been detained behind the bars since 12/6/2025, within bracket for last 51 days, in connection with Tinsukia PS case number 156/2020 under section 420/409 IPC. So the gist of accusation in this case is that on 31/1/2021, Manoj Sutia had lodged an FIR before the officer in charge of Tinsukia Police Station, inter alia, alleging that his land documents have been utilized by the bank manager of Oriental Bank of Commerce for sanctioning a loan in the name of Messrs. BS Trading. The loan the loan was of rupees 50 lakhs. Stop. It is further alleged in the affair that the informant and the present petitioner were shown as guarantor in the said loan, and the loan has become a non-performing assets, and proceeding against SARFAESI Act has been initiated in respect of the landed property of the informant. Learned counsel for the petitioner has submitted that the petitioner is himself a victim in this case, as he also has been made as a guarantor in the loan sanctioned by the co-accused, that is what is the name of the bank manager?
Amit Kumar Jha.
Co-accused Amit Kumar Jha, who was the bank manager when the loan was sanctioned. He further submits that the investigation at the first instance resulted into final report. However, the final report was not accepted by the Judicial Magistrate First Class Tinsukia, and a fresh investigation was directed. It is submitted by learned counsel for the petitioner that the petitioner was arrested from Meerut and was produced before the court, produced before the Court of Learned Chief Judicial Magistrate Tinsukia on transit remand. And since the date of arrest, he is behind the bars. The learned counsel for the petitioner further submits that considering the period of detention further submits that in the meanwhile, the main accused, namely Shri Amit Kumar Jha, has been granted anticipatory bail by, where is that order?
That order, Lordship, page 26. By the Honorable High Court.
By this court. He also submits that as the main accused has been already granted anticipatory bail, the petitioner, who is ready to cooperate in the investigation and who has already been detained behind the bars for last 51 days, may be allowed to go on bail. So on the other hand, learned additional public prosecutor Mr. B. Sharma has produced the case diary of Tinsukia PS case number 56/2020 and has vehemently opposed the grant of bail to the present petitioner. He submits that the present petitioner was the main conspirator in taking fake loan in connivance with the bank manager in the name of SB in the name of which enterprise?
BS Trading.
Mr. BS, Messrs. BS Trading. He also submits that it was the petitioner only who initially asked the informant of the case, who initially gave the assurance to informant of the case that he will arrange him to get a loan from the bank. It is further submitted by Learned. This 5 lakh, it is there, that 5,
Statement I have said it, Lordship.
that there are materials in record, in the record, in the case diary to indicate that the out of the loan amount, the present petitioner had given rupees 5 lakhs to the co-accused, namely the bank manager. He further submits that the petitioner has fled away. After sanctioning of the loan, the petitioner fled away to Meerut and started doing business by changing his name to Shivam Agarwal. He also submits that there are materials in the case diary to indicate that petitioner has also duped many other nationalized banks by taking loan in this manner. He submits that though the petitioner has been detained behind the bars for last 51 days, his custodial interrogation is necessary considering the nature of this case, and hence he opposes the grant of bail to the present petitioner. I have considered the submissions made by learned counsel for both sides and have gone through the case diary of Tinsukia PS case number 156/2020. Considering the incriminating materials available against the petitioner at this stage in the case diary, this court is reluctant to grant bail to the petitioner at this stage. His prayer for bail is rejected.
The accused has been granted 3 years jail, Lordship. If he took that 5 lakh, he is also equally responsible.
They may pray for cancellation of his anticipatory bail.
But they have not yet.
It is our prerogative. We will do as we please.
Item 35.
May please, Lordship, it was called for 2 days, Lordship, the behind the bar 58 days, Lordship.
How many days?
58, Lordship.
What is the offense?
Friends, Lordship. The 112 303 subsection 2 318 4.
No, what is the accusation? What is the allegation?
The sense of the ATM, Lordship, but in the affair, Lordship, he was arrested, then later on lost the affair by the police. And Lordship, the case,
Where is the affair?
affair case, Lordship, 11, Lordship. Carnival, Lordship, the case 15, Lordship.
You changed ATM cards.
So on the
Is it a 90 days offense or 60?
60 days.
What is your
And Lordship, the case
What is your submission?
In 23 lordship, he has the file and anticipatory bail lordship, the police has harassed him to non-affair lordship, the order dated lordship, yeah, lordship. Page 23 lordship, honorable court has passed the lordship. And later he then only suspicion lordship, he arrested lordship. Then lost the affair after arrest. Page 23 lordship.
No, 23. At that time, you were unable to give any detail
No
about
case
the,
pending lordship, the
at that time, no case was pending.
lordship. After arrest, the affair lost by the police lordship.
What
Only
is,
suspicion lordship.
what is the date of your arrest?
He arrest lordship 4/6, but affair lost by 5/6.
Yes. Date of arrest is?
6/6.
But he arrest on 4/6 lordship from his rented house.
What is your submission?
In the footage is available in
Is there
the,
any material against him?
Lordship, he is a habitual offender, Lordship. 1112 is there. It is a PT organized crime, Lordship. What he does, Lordship, in his possession, Lordship, 16 ATM cards of different banks. of-
But after 2 days, you are going to release him. What is the progress in the investigation?
Other persons are also there, Lordship. They are trying to apprehend other persons who accused. Otherwise, materials are there, Lordship. And he is a habitual offender, Lordship. Today's list 39 is also his name is there.
soon arrest case.
Charge-sheeted, Lordship. He is a
No,
charge-sheeted.
that we will consider differently. Heard Mr.
No.
N. Ahmed, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner Ramesh Ali, who has been detained behind the bars since 4/6. What is the date of arrest shown?
In the forwarding, Lordship. It is 6/6/2020.
In the arrest memo, Date of arrest, what date has
Affair
been?
lost 5/6 lordship. After arrest. He is in custody, the footage is already available in the police station.
Date of arrest,
Four.
blank Rakibo. In connection with dispute PS case number 482/2025 under section 112/303 within bracket 2/318 within bracket 4 of BNS. The gist of accusation in this case is that on 5/6/2025,
Arrest memo is also, Lordship, 6/6.
6/6,
6/6/2020.
in 6/6 date of arrest. The gist of accusation in this case on that 5/6/2025. One. Swapnil Bora had lodged an FIR before the officer in charge of Dispur police station, inter alia, alleging that a group of individual including the, what is your name?
Ramesh Ali.
Including the present petitioners are engaged in illegal activities by fraudulently exchanging and swapping, swapping and stealing of ATM cards of various individual stuff. They were mainly targeting old age retired pensioners who visit ATMs for withdrawal of the money. Learned counsel for the petitioner submits that though the petitioner was arrested on 4/6/2025, the FIR in this case has been lodged on 5/6/2025, and date of arrest of the petitioner is shown in the arrest memo as 6/6/2025. He further submits that the petitioner has been arrested only on the basis of suspicion. From 6/6, how many days? 56,
It's 5 days.
55 days.
What is 5 days? First day is not come to 55 days.
Stop. He also submits that the offense involved in this case entails maximum punishment for which maximum punishment of how many years?
Up to 7 years, Lord, sir.
Not more than 7 years. And for which the petitioner may be kept detained behind the bars during the period of investigation, under section 487 of BNSS, only for 60 days. And he has already been detained behind the bars for last 57 days. On the other hand, learned additional public prosecutor has produced the case diary of this for PS case number 482/2025 and has submitted that petitioner was not arrested on 4/6/2025. Rather, he was arrested on 6/6/2025 and he has completed only 55 days of detention. He also submits that there are sufficient incriminating materials in the case diary against the petitioner. What is the progress?
It is other quick is the right to apprehend.
He also submits that there are other co-accused in this case which are yet to be arrested. Yet to be arrested. And therefore, he objects to grant of bail to the present petitioner. So, I have considered the submissions made by learned counsel for both sides and have gone through the case diary produced before the produced by the learned additional public prosecutor. What evidence is collected against him?
Lordship, from the accused person, 16 ATM cards were there. He cannot give the reasoning why this of different persons in different banks. Why this?
Stop.
How he can, Lordship?
Though there are incriminating materials against the petitioner in the case diary, however, considering the fact that he has been detained behind the bars for last 55 days, this court is of considered opinion that if he cooperates in the investigation, his custodial interrogation may not be necessary. In view of above, the petitioner is allowed to go on, above named petitioner is allowed to go on bail of rupees 50,000 with one surety of like amount, subject to the satisfaction of the arresting authority. with following condition, number 1 and number 2. Number 3 of the book. The petitioner shall appear before the investigating of this case, of the aforesaid case, once in a fortnight for next 2 months or till the investigation is completed, whichever is earlier. With above observation, this bail application is disposed of. Send back the case date.
Lordship, the another fellowship 39 charges 7 I approach the law report trial.
39, wait for your turn.
Lordship.
36. It is not available.
Okay,
Commercial competency did not available.
case diary not available. What is your ground?
The articles are recovered from one Vijay Brahma, and I am from Badal Das only, your lordship. And the grounds of the FIR is page number 12, lordship. Kindly go to FIR. I
No,
take-
to appreciate your submission, case diary would be required. When can you produce? Heard Miss A. Medhi Lanet.
This is the second that is, lordship. And
Commercial quantity.
Yes, lordship, but I'm not
It can-
FIR and I'm accused person. According to the Tufan Singh judgment, your lordship, the confessional statement is
FIR is not
the
encyclopedia.
part of the evidence of the lordship.
Produce the case diary on
7th of August.
Putul. 14th.
So much. This is the second that your lordship. This is the second.
Caribbean lordship.
I'm waiting 10:30 to 4 PM, your lordship, for one case only.
You have to wait little more. No, you cannot insist on court. You have to accept, because we are giving dates after looking at, after considering your submission as well as looking our boards. We are giving dates after 25, but in your case, it is 13, 14. So wait till 14. List this matter on 14th of August.
37.
Obliged.
May I please? For the allegation. The allegation is that the accused person sent some videos and obscene video and photograph to the victim girl, and also always that her photograph with him and circulated in social media. Then lordship, the girl, daughter of the informant, consumed poison and subsequently to die. And 306 is added. This is the allegation.
Since when you are behind the
55 days.
Yes,
Yes, lordship. One statement is there of the deceased lordship before the doctor. And she has stated, lordship, that she consumed the herbicide because of this person, lordship. He messaged me in Facebook and such edited videos of me, also threatened to upload my edited naked photos. It is there, lord. May pay those lordship.
heard Mr. H.S. Bora, learned counsel for the petition. What is your submission?
Since I am admitting in my petition that I used to call her, I know her, but this allegation of standing.
You are denying.
Yes.
Heard Mr. H.S. Bora, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner. Namely Rinku Ahmed under section 483 question. Rinku Ahmed in connection with Nalbari PS case number 219/2024 under section 354D slash 509 of Independent slash 509 slash 306 of the Indian Penal Code, read with section 67 of the Information Technology Act. The gist of accusation in this case is that on which date FIR was lodged?
There is no date actually.
2/7/2024.
2/7/2024. One, the father of the victim girl has lodged an FIR before the officer in charge of Kamarkuchi Police Outpost, Inter alia, alleging that the petitioner uploaded obscene photographs of the victim girl in the social media, as a result of which the victim consumed poison. Stop. Learned counsel for the petitioner has submitted that the allegation made in the FIR are not true. He did not upload any obscene photographs in the social media as alleged in the FIR. He also submits that the petitioner has been detained behind the bars for last 55 days, and considering the length of detention, the petitioner may be allowed to go on bail. On the other hand, learned additional public prosecutor you need his custodial detention.
Lordship, materials are there, and moreover, Lordship, other witnesses also stated the same thing. What the witnesses are also there, 183 statements are there, Lordship.
Okay.
Corroborating the
Has
statement.
vehemently opposed the grant of the bail to the petitioner on the ground that there are incriminating materials against the petitioner in the case diary. He also submits that the victim even recorded a dying He also submitted that even a dying declaration of the victim girl has been recorded, wherein he has implicated the present petitioner in the offense alleged in the FIR. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the case diary. Stop. Though the petitioner has been detained behind the bars for last 55 days, however, considering the nature of offense alleged in this case, as well as incriminating materials available in the case diary, his prayer for this court is reluctant to grant him bail at this stage of the investigation. The prayer for bail is therefore rejected.
65 days.
Rejected. You wait for
60 days, up to 10 years punishment.
appeal. Go on appeal. I have already declared.
May it please your Lordship. Lordship, I am for the 38 Lordship. Well, Lordship, this petitioner in jail custody for 50 days, Lordship, otherwise the case is for 60 days offense, Lordship. FIR, Lordship, will find on page 15, Lordship. 280 bags of Lordship urea recovered from the driver Saidul Khan. That is on page 15, Lordship. He was arrested, Lordship. Recovery is made from him, Lordship. Shahidul Khan was forwarded lordship. That report, lordship, a forwarding report on page 17, lordship.
What is your name?
My name is lordship Yusuf Ali.
Why you were arrested?
My arrest, lordship, they said, lordship, he is a veteran supplier of fertilizer. That is not the fact, lordship. I am a registered, I have a trade license that lordship will find on page 27. 27, 28, lordship. Recovery not from me, that is from the driver, specific allegation against some other person, lordship. Case was registered 305E of DNS lordship against along with lordship read with 7 of the EC Act. EC Act is available, lordship. I'm not submitting on that, lordship. Now, lordship, nothing was recovered from the petitioner, lordship, except that is he is a veteran, lordship, supply of fertilizer, lordship, in forwarding report of this
Forwarding report.
of this present petitioner, lordship, will find on page 25, 4, lordship. And there is a reference of another one Anwar Ali, lordship, specifically Anwar Ali was lordship. This court is granted him anticipated bail in lordship another case.
Yes. Yes.
Lordship, lordship, it is during the checking, lordship, with a vehicle, 110 bags of urea was fertilizer was seized, lordship, recovered and seized, and these are the persons, lordship, the petitioners who involved in this transporting fertilizers to other states, lordship, and they are getting benefited from them, lordship. Under the SOP guidelines, lordship, generally retail licenses are required to operate within his or her area of operation as indicated in his or her application and retail license. There should be at least one retailer per block, lordship. Retailers can refrain from selling fertilizers beyond the limits of block. However, in case a retailer nearest to his block is found closed, he can sell it to the farmers nearest to his outlet, lordship.
So he has violated the condition of the test.
Oh, yes, sir. And so standard operating procedure, it is on urea basis in Assam, lordship, as per the SOP, lordship. And it's an organized way of crime, lordship. There are several persons are included, mainly one person named he has included, namely lordship Anwar Ali.
I am not Anwar Ali.
He has to be arrested, lordship, and there are 4 or 5 persons named in the case, lordship, and other persons are involved in this case. They are, and as per their statement also, they are doing this business from a long period of time, lordship.
No, how he is connected with the seized urea? In this case, some quantity of urea fertilizer has been seized.
As per the statement of the driver.
His link is there.
Yes, sir. As per the statement of the driver, main person is Anwar Ali. Anwar Ali is, along with these business persons, they are all involved in this case, lordship. Polar they are transporting area to other states also. The fertilizers.
Recovery from the driver, only driver's accused statement, nothing against the, no independent witnesses, lordship, even then lordship is a violation, lordship, that.
Whether you need his further custodial interrogation.
He also admitted lordship that yes, he is doing this business along with Anurali and transporting the urea fertilizer to illegally to the other states of the country, lordship.
His statement is recorded.
Lordship recorded. And lordship, the main problem is that one person, the main person, which is the
Anwar-
name is Anurali, is yet to be arrested.
Or whether his custodial interrogation would be necessary. How it will hamper.
Only thing that from where they have to supply, these things are not yet to be cleared, but that should be cleared out also. And the main accused should be in custody also.
Heard Mr. B. Chaudhary, learned counsel for the petitioner. Also heard Mr. D. P. Goswami, learned additional public prosecutor. This application under 483 of BNSS has been filed by the petitioner, namely Yusuf Ali, who has been detained behind the bars since 9/7/2025. For how many days?
Lordship already 50 days today, lordship.
Within bracket for last 50 days. How 50 days?
Lordship, it is forwarded on 13/6. There's lordship 13/6, 60, 18
But
days.
you have mentioned your cost
Lordship
cycle.
9/7, sorry, lordship, 9/7, lordship.
If you make wrong submission, I will
Lordship, I
reject
beg
it.
apology, lordship, I beg
without-
apology. Lordship, 9/7, I have mentioned. lordship.
Then how it is 50 days? If it is 9/7,
Lordship, that calculation mistake, lordship, 9/7, lordship.
you have to suffer because of calculation.
Lordship, I beg apology, lordship, I beg apology, lordship. 9/7, lordship, I have stated in my petition, lordship,
So how many days?
and 9/7, 23 days, lordship.
Not at this stage.
Lordship, kindly consider, lordship, because lordship, supply was not made by this petitioner, lordship, the lordship. Moreover, lordship, he having a trade license, lordship.
Also because you make wrong submission.
No, sorry, I'm quoting the arrest of that lordship, driver, lordship. I'm quoting that
And
arrest of the driver.
How many days? 21 days.
23 days, lordship, if I'm not wrong, lordship. 22 days, 1.
Heard Mr. B. Chaudhary. No, 9/7.
9/7, lordship. I've stated
2025 in this, in connection with Vasishtha 324/2025 under section 305 within bracket E of BNS, read with section 7 of the Essential Commodities Act. (1955). The gist of accusation in this case is that on 13/6/2025, one Bhaskar Jyoti Gogoi had lodged an FIR before the officer in charge of Vasishtha Police Station, inter alia alleging that on receipt of any information through reliable sources that one vehicle bearing registration number AS28C 9430 was carrying illegal urea from Barpeta en route to Meghalaya via Zorabad. A Naka checking was organized and the said vehicle was intercepted. From the said vehicle, 280 numbers of bags of urea. Was recovered. And one Shahidul Khan was arrested from the state vehicle. The counsel for the petitioner has submitted that the petitioner is not involved in the offense alleged in the FIR. He submits that nothing was recovered from the possession of the present petitioner in this case. He submits that the petitioner has been arrested merely on the basis of the statement of one of the co-accused who has implicated him of being a veteran smuggler of urea fertilizer in the said area along with one of the main co-accused, Anwar Ali. He also submits that the petitioner has been arrested only on the basis of suspicion, as it is also submitted by learned counsel for the petitioner that the petitioner is the holder of a wholesale license for fertilizer. He carries on business of fertilizer from his firm Messrs. Maromi Beach Bandar. He also submits that the petitioner has been detained behind the bars for last 23 days. On the other hand, learned additional public prosecutor has opposed the grant of bail to the petitioner. Mr. Goswami, what materials are there to show his link with these 280 numbers of bag of urea? Apart from general statement that he is also involved in similar, with these 280 bags, can he be connected? Learned additional public.
His petitioner of ship escorted the vehicle. As per the statement of the driver of ship, his petitioner escorted the vehicle to pass the. The only thing is that co-accused statement and the driver's statement that he is associated with.
No, maybe at this stage, it is early stage, but how they have been implicated? He is associated in what manner? Mere statement will not do. What was his role? No, for that you cannot hold all the retail agents.
Those were the marks of the government. Pradhan Mantri logo was there.
Yes, no, my query is how he can be connected with the seized urea. Is seized urea, 280 bags of urea was seized. The accusation is that it is illegally transported. And one particular person was arrested in possession. Now, the co-accused statement says that he also indulged in similar kind of activities. That is one accusation. Whether he can also be connected with the urea which was seized in the particular case, in this particular incident.
The government. So it is subsidized
urea meant for the farmer. And he being a retail agent lordship, he diverted those urea to the other intermediaries to be transported to other states, which is not permissible by the, in view of the standard operating procedure.
So, learned counsel for the petitioner, learned additional public prosecutor also submits that the petitioner has violated, though petitioner has the trade license of fertilizers. However, he has violated the standard operating procedure of the government in this regard. And this urea, how is linked? Whether the driver has stated in his
Not on this
wallet.
urea, he's not stating in about this fertilizer, lordship, but he's stating that, yes, he's associated with random damage, not in this recovered from this vehicle.
Whose urea is this?
It is, urea is Anwar.
Okay. And he
He has
also.
instructed to load the urea fertilizer.
Yeah, लिखा. Last. And in this, while dealing with the business of fertilizers, he also submits that one of the main accused, namely Anwar Ali, is yet to be apprehended in this case, and therefore prays for and therefore oppose the grant of bail to the present petitioner. I have considered the submissions made by learned counsel for both sides. It appears that though accusation have been made by the co-accused against the present petitioner of being involved in the offense of illegally transporting urea. However, in case of the urea which has been seized in this case, the other co-accused, complicity of the other co-accused, namely, the materials are there indicating to the complicity of other co-accused, namely Anwar Hussain. Anwar Ali. And no specific material is there in the case diary at this stage to link the present petitioner with the urea seized in pursuant to the allegation made in the FIR in the instant case. Stop. In view of the aforesaid facts, this court is of considered opinion that if the petitioner cooperates in the investigation, his custodial detention may not be necessary for fair completion of the investigation of Joraba. Investigation of which case?
Boshisto PS case number
Vashishtha PS case number
324/25.
2023. In view of above, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount subject to the satisfaction of learned Chief Judicial Magistrate, Kamrup Metro, with following conditions. Number 1 and number 2. Send back the case diary.
Highly obliged.
This bail application is accordingly disposed.
Highly obliged. Same case, my lord, but he was arrested, my lord, on my lord 6/7/2025, my lord. And allegation,
Mustafa.
yes, an allegation against him that, my lord, that the vehicle, my lord, he was escorting that vehicle. And the person from whom it was recovered, my lord, so he has been.
When you were arrested?
I mean, custody from 6/7, my lord.
How many days?
And here, madam, definitely everything has been recovered. Other co-equals.
How many days?
20, 26, 25, it will be 25 days. Okay. And madam, the co-equals from whom it was recovered, granted them that order also annexed, madam. And another aspect here, madam, that 35(3) notice, why not given? They have stated that he will not comply, madam. Possibly that cannot be a ground. Otherwise, madam, that section 7 is a bailable offense, madam. Fertilizer will be within the ambit of that offense, my lord. And other section, my lord, it is extended to 7 years, my lord, that 3052, my lord. That is theft in a dwelling house, my lord. And means of transfer, that may not be attracted, considering the length of detention.
Yes.
The reference statement of the driver of it, they escorted the vehicle. And when police trusted the vehicle, they fled away from the place of occurrence. And they also instructed the driver to load the urea. That is in the statement of the driver.
Materials are there
Yeah,
against
material.
him.
Oh, it is granted, kindly evaluate.
Co-accused is just now.
No, the person from whom it was recovered, my lord.
The driver has been,
Yes.
where is the
That order, also kindly have a look at page 70, my lord.
page?
70, my lord. My lord, relevant part, also kindly see page 71, my lord.
By the trial court?
My-
Who is Afzalur?
After possibly his, that accused person's some relative, my lord. He preferred that application possible.
Abdul Rahman.
Same forwarding, my lord.
Abdul Rahman was also escorting.
No, he was in that vehicle, my lord.
From his person, the
That-
fertilizer also recovered.
Same forwarding, Lord, will kindly have a look at page 31, my lord. 31 and 30.
Okay. No, why he was granted, what logic?
Logic, you can see that page 71, my lord, because on perusal of case diary, that also kindly see. Statement of vital witness have already recovered and so, no development.
Okay, heard Mr. A. Chaudhary, learned counsel for the petitioner. Also heard Mr. D.P. Goswami, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Mustafa Amin, who has been detained behind the bars since 6/7/2025 in connection with Agor case, earlier case, Agor case of GSL in connection with so and so. The gist of accusation same. Learned counsel for the petitioner has submitted that the petitioner has been detained behind the bars since 6th of July 2025, and the accusation against him that he was escorting the vehicle in which the illegal urea was found. He also submits that since the illegal urea has been seized and since one of the co-accused, namely Abdul Rahman, from whose possession from Abdul Rahman's possession, urea was seized, from whose possession the urea fertilizer was seized, has already been granted bail by the Court of London. Trial Court of London, Judicial Magistrate First Class, Kamrup Metro, by order dated 28/7/2025 in case number, Vasishta PS case number 324/2025, further custodial interrogation may not be necessary, of the petitioner may not be necessary. He submits that petitioner is ready to cooperate in the investigation if he is released on bail. So on the other hand, learned additional public prosecutor has produced the case diary of Vasishta PS case number 324/2025 and has opposed the grant of bail to the present petitioner on the ground that there are incriminating materials against the petitioner in the case diary. He submits that the petitioner was found escorting the vehicle from which the illegal urea fertilizer was seized. I have considered the submissions made by learned counsel for both sides. Though there are incriminating materials against the petitioner in the case diary, however, considering the fact that the illegal urea and the alleged illegal urea has already been seized, and in the meanwhile, the accused from whose possession urea was recovered, one of the accused from whose possession urea was recovered, namely Abdur Rahman, has also been granted bail. This court is of considered opinion that if the petitioner cooperates in the investigation, his custodial interrogation may not be necessary. So, in view of above, the above named petitioner is allowed to go on bail of rupees, same order 30,000, Agor order list.
Much obliged. Thank you.
49. 49 I think in this case has 600.
Your sheet submitted. Heard Mr. N. Ahmed, learned counsel for the petitioner. Also heard Mr. D.P. Goswami, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid, bearing charge sheet number
106/25 dated 36/25.
So in view of the fact that charge sheet has been submitted in this case, this bail application is disposed of with a direction to the petitioner to approach before the trial court and pray for regular bail before the said court, if so advised. Please, Sumatu.
The section is 22C, 4197, but some ground is lordship are arrest is lordship unconstitutional and illegal because of not submitting the notice 47 and 48 lordship. And on the last occasion lordship, page 27, page 21 lordship, this is in respect of 47, 48 lordship, and they have submitted to the one Orup Pushkami lordship, who is neither the fan nor family member, nor any connection with the petitioner lordship, and my learned son is supposed to notice anything.
You could find who is Arup Goswami.
He was appointed lordship. He has the authority to be appointed as such lordship. One notification is also there. However, one
What notification?
notification is there. Lordship. In pursuance of this department, I'll have to ensure lordship reconstitution of Thana level Nagarik committee. the Governor of Assam is pleased to notify the list, chairman member of Nagarik Committee in each functional police station, fight annexer A. And in this list, Lordship, this person's name is also there. And in every functional police stations, these Nagarik committees were there, Lordship, form for those persons who are outside, Lordship, this West Bengal. And in the one note is also there, Lordship. In that note, Lordship, may I read, Lordship? At the time of the arrest, no family members, relative or friend of the accused was present to receive the notice of arrest as required under section 48 of the BNSS. Accordingly, an email has been sent to OC Sahibganj, that is in the West Bengal, Lordship.
No, then you have to ask the arrested person.
No, it is there, I am on that, Lordship. The arrested individual was informed of the situation and was asked to nominate a person to be informed on the grounds of her arrest. As per the provisions of BNSS, the accused voluntarily nominated Sri Orup Goswami.
Yes, then it is
Chairman.
complaints.
My lord,
It is complied.
how Lordship Arup Goswami, she is from, Lordship, the lady is from Kuch Bihar, Lordship.
No, but you nominated.
Lordship.
This statement is, Lordship,
It is there, Lordship.
and as per the judgment, Lordship, so it is nominated, but how she can nominate a friend, relative, something.
Not,
outside.
no. He can nominate anybody.
Lordship.
Mhm.
And Arup Goswami, Lordship, she does not know about the Arup Goswami, who is Arup Goswami, and finally see, Lordship, in this notice, Lordship, what has been stated, Lordship. Just informed that she was arrested, and then nothing has been stated, requested, no request is there to communicate her relatives, family members, or
Email has been
concerned,
sent,
people. Nothing has been stated.
No, that is not necessary. The notice, the grounds of arrest are to be communicated to friends, relative, or the nominated person. Now, you may challenge that.
But this note, Lordship, and
But
Your Lordship,
it is in the stage of investigation. At this stage of investigation, we have to go by the,
Lordship, because it is not believable, because at the time of search, Lordship, may I submit, Lordship, at the time of search, Lordship, the FIR itself, it is stated that she disclosed her names, her age, her husband's name, her address, everything, on the page 15, Lordship. And in the FIR, if it is, if she nominated, then in the FIR itself, it could be mentioned, Lordship.
no affair.
Page 15, Lordship, kindly see, Lord. She, during preliminary inquiry, she identified
Moreover, Lordship,
herself as
I also want to point out another thing, Lordship.
Warbina Kumar.
This person, this Arup Goswami is at the police station, was present at the police station at the relevant time, and she nominated her. He said how he knows. Everything is communicated to her, everything, Lordship, and he is also present at the time, and she nominated him, Lordship. The person.
Who is Arup Goswami?
Arup Goswami is the authorized nominated person, Lordship,
Otherwise, he is the member of.
member of Lordship, this committee.
Okay. Okay, I'll consider. Third.
And regarding memo, arrest memo, I have also pointed out, this is also mentioned in arrest memo, Lordship, the witness is required, there is no witness is required, mentioned, Lordship. In the arrest memo page.
However, one
22,
maid is
Lordship.
also communicated, Lordship.
So, Lordship, as per the judgment of Lordship Bihan Kumar, Lordship, this may not be as a formality, Lordship. The paragraph 42, Lordship. This may not be a formality, Lordship. Kindly may I read, Lordship. The purpose of inserting section 50A CRPC, making it obligatory on the person making arrest to inform about the arrest to the friend.
No, okay.
Lordship.
In this case, the issue, you are contesting the claim of the additional PP that You have not nominated Arup Goswami.
Lordship, and if Arup Goswami, who is Arup Goswami, Lordship, he is a member, chairman of a committee here, Lordship. I mean, the lady who is arrested, he is in West Bengal, Lordship.
No, maybe,
How he will be
but
communicated?
your submission is that you have not nominated.
I have not nominated, and Lordship,
PP is submitting that there are endorsement in the case diary to indicate that.
in addition to my submission, Lordship, that cannot be a mere formality, Lordship, to submit send the notice, Lordship, under section 48. And it is clearly mentioned, Lordship, in addition, in the middle of the para, in addition to his relatives as mentioned above, is not merely a formality, but to enable the detained person to know the reasons for his arrest, but also to provide the necessary opportunity to him through his relative friends or nominated persons to secure his release at the earliest possible opportunity for actualizing the fundamental right to liberty and life as granted under Article 21 of the Constitution. So,
Heard Mr. A.M.S. Majumdar, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Parbina Khatun Bibi, who has been detained behind the bars since 7/5/2025 in connection with Panbajar PS case number 161/2025 under section 22C/29 of the NDPS Act. The gist of accusation in this case is that on 7/5/2025, one Debojit Vaishnav had lodged an FIR before the officer in charge of Panbajar police station, inter alia, alleging that on receipt of an information through reliable sources that some narcotic substance will be carried, is being transported from Silchar to Guwahati railway station. A search team was constituted and stop. The said team arrived at platform number 3 of the Guwahati railway station on the said day and intercepted the suspect in front of a tea stall named Ram Bhajan Gond. The suspect was identified as Miss Parbina Khatun Bibi within bracket present petitioner, and during search one brown color, one packet wrapped in brown color tapes was recovered from her possession. The said packet contained, what was the contraband?
20,000 tablet. Suspected Yoba tablet.
Oh, contained 20,000 20,000 suspected Yaba tablets. Contain 20,000 Yaba tablets suspected to contain methamphetamine. learned counsel for the petitioner has submitted that in the instant case, there has been a violation of the guidelines of the apex court in the case of D.K. Basu versus State of West Bengal, reported in 1997, 1 SCC 416, inasmuch as no witness was present at the time of the arrest of the present petitioner, as no signature of any witness has been taken in the arrest memo, which was prepared at the time of the arrest,
Oh, my lord.
as required.
Arrest paper, this is not my submission. At the time of arrest, witnesses were there, but the arrest papers was prepared later. It is major. Because if, as per FIR, there is 3 witnesses at the time of search. If there is any person.
ಇದು ಲೈನ್ ತು ಕಟ್ಟಿದ್ಯೋ ಈ ಲೈನ್ ತು ಕಟ್ಟಿದ್ಯೋ Learned counsel for the petitioner has submitted that in this case there has been a violation of the guideline of the apex court in the case of D.K. Basu versus State of West Bengal, reported in 1997, 1 SCC 416, inasmuch as the arrest memo was prepared later on and no signature of witnesses is taken on the arrest memo. Is there signature of witnesses?
No, there is no.
Stop. Which is required as per the observation made by the apex court in the aforesaid case. He also submits that in the instant case, there has been also violation of the requirement of furnishing requirement of communicating grounds of arrest, in writing to the friends/relative/nominated person of the arrestee. He submits that in this case, notice under section 48 has been served. Notice under section 48 of BNSS was served on one Arup Goswami, who was never nominated by the present petitioner, as he is neither a friend nor relative of the present petitioner. Stop. Learned counsel for the petitioner has submitted that as the apex court in the case of Vihan Kumar versus State of Haryana and another, reported in 2025, 5 SCC 799, has observed that to make the mandate of Article 22(1) of the Constitution of India meaningful and effective, it is required that the grounds of arrest in writing is not only communicated to the arrested person, but also to friends, relatives, or such other persons as may be disclosed or nominated by the arrested person. So, he submits that as there has been violation of the said mandate, the petitioner is entitled to get bail in this case. On the other hand, learned additional public prosecutor Mr. K.K. Das has produced the case diary of
Panbajar 161.
what is the case number?
Panbajar 161
Case diary of Pan Bazar PS case number 161/2025 and has vehemently opposed the grant of bail to the present petitioner. He submits that the petitioner, he submits that there has been no violation of any statutory requirement, statutory procedural requirement, or any constitutional mandate in this case. He submits that he also submits that in the instant case, at the time of arrest of the petitioner, three witnesses were present as seizure was made in presence of those witnesses. And he also submits that that in the case diary, the investigating officer has clearly indicated that as the petitioner hails from West Bengal, it was not possible to intimate the relatives and or friends of or any friend of the petitioner at the time of his arrest, her arrest, and the petitioner, on being asked, herself nominated Shri Arup Goswami for the purpose of furnishing grounds of arrest as required under Article 22(1) of the Constitution of India. He also submits that Arup Goswami, Shri Arup Goswami, who was nominated by the petitioner, is a member of, yes,
Reconstitution of Thana level Nagarik Committee.
a member of Thana level Nagrik Committee constituted under
There is a notification.
under notification number. Flag that.
I have flagged.
Stop. ... Remaining A2 type query move soft copy DP. On Wednesday, Nikhok heard Mr. AMS Majumdar, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. List this case for delivery of orders on Wednesdays, 6th. You give me the case then.
Hold on. I had a regular bail of the production list. Tuesday one. Well, at item 44, it is fourth time it is left over. Fourth time. So, Lordship may kindly fix on Tuesday at 2 p.m. as the fixed item. Otherwise, again, fourth time it is left over. My one is a regular bill. Tuesday, if possible. Item 44.
Item
44. My one is a production list 1.
No, only one of you should submit at a time.
I was the first to submit. Production list item number. Can it be on Tuesday? The regular bill.
Okay. On Tuesday.
And 44 also, my lord, on that day at 2 p.m.
Tuesday ki maina. Okay, on Tuesday.
I'm okay.
44 also on Tuesday.
Tuesday at 2 p.m.
No, not on that day. You may make some mention at what number it get listed. You see the cause list, and thereafter, if you have apprehension, you may make prayer.
So I have a similar prayer, item number 47, maybe on Wednesday or Thursday, Lord, if possible. It is item number 47.
47, what is the matter?
This is the IF for amendment of the bail order, Lordship. 2 months back, I got the bail, Lordship. But due to the bail condition, I am unable to get out of the jail, Lordship. The bail condition is that the surety has to be from the Siribhumi district, and I am a resident of Guwahati. I am finding it almost.
Okay, okay. Okay. And then Tuesday.
Lordship, I have a prayer
Item number,
Lordship, I have a prayer for 46, Lordship. This is also, Lordship, fourth time, Lordship. Can it
In,
be on
in
Wednesday?
Itanagar bench, when bar makes mention, they maintain a very good discipline. There is never overlapping. But in principal seat, there is always overlapping. Nobody gives ways to.
I'm done. Lordship, regarding 46, Lordship, on Wednesday, Lordship. Fourth time, Lordship, is there.
46.
Yes, Lord.
Okay, on Wednesday 40. Sabote likhibo, due to paucity of time, this matter could not be taken up today. Place this matter on so and so. Okay.
Obliged.
item number 43, Your Lordship, I am on interim till today. It may be.
Interim will continue on CDs there on Tuesday.
Deeply obliged.
So I think 41, Lordship, this is long pending matter, Lordship, this one 24 matter, Lordship, any fixed date, Lordship. 41, Lordship, we have the case, the even this one up to date. And the up to date is on 27 February.
When you can produce the update, he said. Updated case, item number,
41.
you are on interim.
No, Lordship, no interim there. Short date may be given.
When can you produce the case there?
It's from, Lordship, 13, 12, 13.
Little short date may be given.
13.
Since 1 year pending, Lordship. Since from 20.
Since 1 year, you are not on interim.
Yes, since very beginning, not interim, Lordship. They are not in interim, Lordship, including searching the prisoner, Lordship. The
13.
owner of a cattle, Lordship. 13. Already Zimmer given to him, Lordship.
13.
Obliged.
My lord, sorry for the inconvenience, my lord, as I am informed that item 40, my lord, charges has been filed, my lord.
Yes, Lordship.
You are on interim.
Yes, my lord.
Heard Mr. B.M. Deka, learned counsel for the petitioner. Also heard Mr. D.P. Goswami, learned additional public prosecutor, who submits that though case diary was called for, however, in the meanwhile, charge sheet has been laid bearing charge sheet number.
83/24 dated 25/2/24.
Learned counsel for the petitioner submits that the petitioner was granted interim bail by this court on
18/08/2023, my lord.
and he has complied with the
Yes.
directions of this court and has cooperated in the investigation. Considering the submissions made by learned counsel, the interim bail granted to the petitioner is hereby made absolute.
Much obliged. Much obliged.
In item number 42, Lordship, I'm on interim. The CD is also
42.
available.
CD is available.
Here of CD is available, Lordship.
Tuesday.
Yes, I'm complying the honorable court's order. Pre-arrest bail was granted, then I have appeared before the.
Then interim. There are some another date, Lordship. We have to go to the case.
He has appeared.
Yes, appeared. So you have to go to the case after going to the case, Lordship. Fix the date.
No,
Category A offense,
he-
Lordship. So far, until judgment is concerned, up to 7 years.
What offense?
406 and 420 earlier CRPC. Criminal breach of trust and cheating. So this will not go together as per the judgment of the honorable court.
You have any submission? We will make absolute.
So more to.
Okay, on Tuesday, we'll consider.